Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul, and I will guide you on a 3-hour journey through Courtlandia, starting with Magistrate Chisholm in Royal Oak, Michigan.
In 2599A. One citation was for driving on expired plates. The second was no proof of insurance. When did you get the new plates or TAS, Mr. Walker?
I can go to my vehicle to get that exact information for you right now. Just one moment.
We'll put you back in the waiting room. Sick. And what is your name, please?
Yes. You asked for my name?
Yes, please.
Yes, Ariel Lapchuk.
Mr. Lapchick, your ticket bears the caption 26BE03466. You were ticketed for driving on expired plates back on the 7th of July. When did you get the new plates or tabs?
Yes, I got them in probably about a few days later. I don't know the exact date, but here's the new
Can you put that a
registration.
little closer to the camera and then speak, and the sound of your voice will make the camera focus on you and we can read it.
Sure. I got it about a few days after that ticket, either 2 days later. I don't remember the exact date, but here it is.
Right. The exact date is in the bottom left-hand corner.
Oh, bottom left-hand corner, 7/7/26, July 7th, 2026.
Same day you got the ticket.
Oh,
Is there anything you want to add to this, Officer Donnelly?
what's that?
I asked the officer if he had anything to add.
Oh,
Yes, Your Honor. Motion to dismiss.
Thank you. Mr. Lapchick, you were good to go. The ticket is dismissed thanks to the officer's motion.
appreciate it. Thank you very much, sir.
Thank you. See if Mr. Walker is back. You have the registration, Mr. Walker?
I do have the registration. You had asked for the date that the registration was updated. That was on June 8th at Oak Park Secretary.
You would turn on your camera, please.
Oh, I'm sorry.
If you put the registration in front of the camera and then speak, we can see it.
So when I look, yeah.
Okay. Is there anything you want to add to this, officer?
Motion to dismiss, Your Honor.
Thank you. Mr. Walker, you're good to go. Thanks to the officer's motion, the ticket is dismissed.
Thank you very much, Officer Donnelly. Thank you, Your Honor.
Oh, there's the other ticket.
Take care.
No proof of insurance. When you were stopped that day, was your vehicle insured?
It was not, and not to my knowledge. I was under the impression that a friend of mine had put this vehicle into our new fleet insurance for a small rental company. It was not, in fact, insured that day.
That one is different than plates. The fine on that is $175.
Okay.
It can be paid online or by mail. There are no points for that, but there is a substantial fine, and it can be paid by mail or online. Or if you prefer, you could drop by the courthouse and pay it at the counter, whatever works for you.
Perfect.
Thank you.
Thank you very much.
Okay. This is citation 26BE02409. Ms. King, you were cited back on the 14th of May for parking on the street between 2 a.m. and 5 a.m. You can admit or deny responsibility for that, or you can admit responsibility with an explanation. How do you wish to proceed?
I would like to admit with an explanation, Your Honor.
And what is your explanation, please?
Yes, so that day my wife and I went to a Tigers game, and we went over to my friend's house to go to the game. And we had parked on the street, and we Ubered from there to Detroit, and he lives in Berkeley. And when we came back, we had no intentions on staying the night, but we had too much to drink, and we thought that it would be safer to stay the night. And he had only been living in Berkeley for a little bit, and he wasn't exactly sure how the parking had worked, but it was under his understanding that to park on the street, that everyone got like something about 5 free every year, or 5 like free parking, something like that, and that they like kept tracked by license plate or something like that. So he wasn't exactly sure, but we just all thought that it would be safer and smarter for us to stay the night, and that we didn't want to drive safe, or we didn't want to drive drunk, and we wanted to be safe. We thought that was the smarter, more responsible decision to do that. And we didn't have room.
Not to get drunk.
Well, yeah, of course, but it was opening day. My sister was in town from Nevada, so we we had a little bit too much fun, and that happened. So it was a little bit crazy, but the tickets kind of took us by surprise too. I thought maybe it'd be like $10. And unfortunately, I live a little bit outside of my means financially, because I've lost both my parents. Tomorrow is actually the 6-year anniversary of my dad passing away to cancer. And a year and a half after that, I lost my mom to cancer too. And I'm in my childhood bedroom because I bought my house from my siblings. And so like seeing that those tickets were $50 each really, really kind of took me, for a surprise, and that was really expensive. And then I said I was gonna, try to take it to, court and just talk about it. And then I missed the hearing because I never got the piece of paper in the mail. And then my wife was really upset with me. And then so I, did everything that I needed to do to default and bring it here today as well. So I'm just here hoping that maybe we could come to a compromise as well, because I really made a lot of mistakes in a row. So absolutely admitting fault.
I'm going to waive the default, and that will return $45 to you.
We had 2 tickets, Your Honor, one for each of our cars because we drove separately. I don't know if you saw that.
Yeah,
I have 2 hearings today.
yeah, you do. I'll do the same thing on both.
Thank you. I do appreciate that.
So fine is 50. And waive default.
Is there a way that you can park overnight in Berkeley?
If something
We were trying to
happens
understand
and you
that.
have an emergency, you can call the police department,
Okay.
and they will, if the circumstances meet their criteria, they issue a one-time pass, if you will. And I don't think you even now have to go into the police station to get it. I think they just put it on a sheet.
Do you have the non-emergency number that you can provide to me?
Hi there. So, first off, very sorry to hear about your parents. Glad we're able to take care of you today. Just for future reference, you are able to park in the street between the hours of 2 and 5 a.m. You just got to go on the City of Berkeley website and just apply for a pass. So you just put in your license plate number and they would issue you a pass for the evening so that way you don't get any kind of, citation. Okay?
Hmm. Okay, so you can do that. You have
Yep.
to just apply for a
Yep.
pass. Okay.
You just go on the City of Berkeley website. It's super quick. You just put in your license plate number there and it'll grant you a pass for the evening.
It used
Okay.
to all be paper.
I'll tell that for my friend because like we were really just trying to be safe and smart, obviously. Because it was a weekday. We had to work the next day. Woke up early the next morning to those tickets and went to work. So um it was not a good morning. And my wife also lost her dad 2 years. Like it was like 2020, my dad died. 2022, my mom died. 2024, her dad died. So like we haven't been having the best few years, and then like financially we haven't been in good places. So like she's been pretty angry too. Like her grief is anger, my grief is just sadness. So she was really, really mad at me. Um, and she's still really mad at me. And so these tickets haven't been helping, especially when I said I was going to take care of it and I didn't.
Well, when the $90 comes back, why don't you keep it?
No, it's all the same money. Um, yeah, she got really mad about the extra money. And um I don't know. She told me to just pay them, and I thought I could at least get online and try
We
to
can split the difference
waive
with you,
one of
Mason.
them. Yeah.
Well, we split the difference on both. Thank you.
Thank you.
Take care.
You too. Bye.
Good morning once again, everybody. It is TCF Live on a Tuesday. It's good to have you all here. I'm just going to make a comment based upon almost 2 years now of doing courtroom content. If we're going to start using grief as an excuse for everything, then everybody's going to get away with everything. It is just so prevalent out in our courts. I'm not to be insensitive. It sucks to lose people. I've been through it. I understand. But it is not a get out of jail free card. Anyways, just saying. Slow start in the courts this morning. We're going to ride with the magistrate for a little while longer.
Advise that I attend to avoid a default judgment and let you in the court know.
Okay, so you've already paid it, so it's closed.
Yes.
Yeah. Okay. So I'll just note that you paid online. And you did that yesterday, so that would be the 3rd.
Yes.
So you're good to go. Thank you.
Thank you. Have a great day.
You too.
Bye.
And I can help you go.
Okay. I didn't know if I leave or you guys kick me out.
I'm not kicking you out, but you're good to go. Okay.
Thank you. Bye.
Maybe I kicked out the wrong person. I did. I hope they come back. In the event that they don't, that's not a default. We'll just reschedule it. I think it was full. Yeah. Yep. We have Nicholas and Tony. Let's see if I can get him in without kicking him out. Okay. This is 26 BE 03012. Mr. Abdoni, you received a parking ticket back on the 12th of June. It was issued at 4:51 for parking on the street in Berkeley between 2 and 5 in the morning. Are you here to admit or to deny responsibility, or to admit with an explanation?
I had a parking pass in my car
From whom?
from the city of Berkeley, a yearly residential parking pass.
Can you put that in front of the camera?
Shoot, this is blurring. I took a photo of it as I was coming into work
If
today.
you unblur your background, it'll work.
Let's see here. It says I have none selected.
You got the blurred background going, so I don't know how
Yeah.
it got there.
Let's see.
Officer Donnelly, do you recognize the pass?
Yes, Your Honor. And, I apologize if I made a mistake, if you had that in the window. We definitely, if that's the case, I want to make that right. And if that instance were to ever happen again with another officer, definitely feel free to call the department. We can take care of that ahead of time before it, heads to the court. So I apologize.
Thank you. I appreciate that. Yeah, my pass is number 038 and it's always in that window there. So I appreciate that. I'll certainly call the station should it ever happen again.
If you call the station, then they submit a list to the court and it's dismissed administratively, and you wouldn't need to take the time to come here this morning.
Okay.
So, okay. And
Motion to dismiss, Your Honor.
Sure. I understood that is what you meant, and I already did it. So you're good to go, sir.
All
Thank
right.
you.
Julie, good morning, calling out the wood paddle and the wood sword on the officer's wall. I noted that as well. Very interesting choices. Anywho, good morning once again, everybody. Got a few other options in court now. Let's go to Kalkaska, Michigan. Judge Mertz.
Mr. Seeger, how do you want to proceed on this file?
Yeah, I think that there's a resolution. However, if the court would give us one final action date for us to either accept or reject a plea, I think that the file is likely to be resolved. She did ask me to go back to the prosecuting attorney to ask for perhaps a different variance. I did, prior to discuss her asking me to do that, I did have an opportunity to speak with the prosecuting attorney, for which, at least at that time, he was uninclined to amend the offer. But be that as it may, Your Honor, if the court gave us an additional 30 days, I'm confident that we'd be able to resolve it at the next date.
Mr. Ziegler?
I don't have any objection to a 30-day adjournment, Your Honor.
Okay. I believe this is Ms. Knapp's first appearance before the circuit court. This matter was just found over recently. I think it's reasonable to allow a little extra time for plea negotiations. So, Ms. Knapp, the court's going to set this for a hearing at the beginning of September. You'll get a date and time of that hearing just as you did for today. Between now and then, it's important that you stay in touch with your attorney and that you're ready with a final decision as to any plea offers on that next date.
Okay.
Do you have any questions at all?
No.
Thank you. That's all for today.
Thank you.
We're a little ahead. Mr. Seeger, do you have any other clients?
Ms. Gable is here and Mr. Patrick is here.
Mr. Patrick, if you come forward, please. The court will call People versus Dustin Patrick, file number 265195. The record should reflect Mr. Patrick is present here in the courtroom today. Mr. Seeger, how did you want to? Oh, I'm sorry. This is the date and time set for sentencing in this matter.
It is, Shane.
Okay. Mr. Patrick, have you had an opportunity to go through the pre-sentence report?
I have.
Okay. Have you had an adequate opportunity to speak with your attorney about that?
I have.
Mr. Seeger, do you have any additions, deletions, or corrections to that report?
No, Your Honor.
Do you have any challenges to the scoring?
I do not. No.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, I would simply ask the court to adopt the recommendations. This is the defendant's first felony sentencing. He has 4 prior misdemeanors, no prior felonies. I think he's a good candidate for the 7411 program. I'm hopeful that he will take full advantage of that and be successful if the court decides to give it to him. But otherwise, I would just ask the court to adopt the recommendation.
Thank you, Mr. Ziegler.
Your Honor, I tend to agree with Mr. Ziegler. Mr. Patrick has expressed a great deal of want to be successful on his probation. He has also expressed the want to have an opportunity to not have a felony on his record. Because he has no prior felonious history, hopefully that is a very much an incentive for him to successfully complete his probation. He's been in regular contact with me, so I assume that he'll be in regular contact with the probation department. I assume that he'll follow through with the objects of it. He didn't indicate to me that this has been very much a learning lesson for him. He needs to make better decisions, which he indicated that he will going forward. If given the opportunity to be placed on 7411, I have no reason to believe that he will successfully complete it.
Thank you. Mr. Patrick, anything you want to say?
No.
Well, I did read through the report prior to the hearing today, so I'm familiar with all the information in that report, including the circumstances that bring you before the court today, as well as just generally your background and your circumstances as well. And you know, I guess the thing that struck me about the incident itself is just, you know, how dangerous it is to be riding a motorcycle under the influence of alcohol and cocaine. I mean, you put yourself in a position where, I mean, I used to ride, so I get it. Yeah. It's hard enough when you're completely sober. Yeah. And so I hope it is kind of a wake up call for you because you don't want to put yourself in that position. You don't want to put yourself in a position where you could hurt someone else by riding in the condition that you were in. I do think that there, you know, based on your prior history and your age, that there is a good chance for rehabilitation here. And so I do think that probation is an appropriate way to address the conduct. I'm not going to impose any upfront jail time. I'm going to hold some jail in advance. Hopefully to act as a motivator for you to the extent that you need additional motivation to comply with the probation. The benefit to you to the 7411 probation, as I'm sure you know, is that if you successfully complete it, this comes off your record. That's, you know, that's a huge benefit. And I don't think there's any risk to the community in giving you the opportunity to do that, particularly with your lack of any prior felony history. So I don't see any reason not to agree with the recommendation. So the court is going to place you on probation for a term of 24 months. If you do well on probation, you'd be eligible to have a significant portion of that time reduced, which is another benefit to complying with probation. The court is going to make that probation pursuant to the 7411 statute. I am going to adopt as the conditions of that probation all the terms and conditions listed in this report. And that includes that you comply with any alcohol or drug testing and that you not use or possess any controlled substances or drug paraphernalia unless they're prescribed to you by a doctor, along with all the other terms and conditions. The court is going to impose 90 days in the Crawford County Jail with third credit for 32 days served, that time to be held in abeyance to be served at the discretion of the court. The court will order a crime victim's assessment of $130, court costs of $325, fine of $325, attorney fees of $350, and a $68 state cost, as well as a supervision fee while you're on probation of $30 per month. Because the probation is pursuant to 7411, there are no appellate rights at this time. Ms. Wagner, would you like Mr. Patrick to stop by the probation office before he leaves court today?
Yes, please. Thank you.
So, Mr. Patrick. Oh, Kalkaska County Jail. I'm sorry. In terms of the jail sentence, of course, that would be Kalkaska, not Crawford. I misspoke. Mr. Patrick, before you leave today, please stop by and meet with Ms. Wagner. Do you have any questions?
I do not.
Good luck to you going forward.
Thank you, sir.
TCF Live. It's Tuesday, my friends. Good to have you here. We're going to go into the Wayback Machine for a few minutes. So yesterday we were watching a hearing with Judge Boyd. It got our attention so much that it's going to be the subject of sidebar tonight. Or no, not tonight. Thursday. Doesn't matter. Anyways, it's going to be a sidebar. But we never got to see the conclusion because that happened after we went off the air. But I have that for you, so here it is now.
All right, we're back on the record in 2026 CR 004753, State versus Charlie Perkins. Can I have parties re-announced for the record, please?
Joseph Davidson, defense attorney.
All right, so State, did you have a chance to review the testimony for just 1 second? My computer's doing something crazy. All right, State, did you have a chance to review any independent evidence on whether or not the defendant was previously shot before this incident?
Yes, Judge, I did ascertain a police report for the incident referenced. I have marked it as State's Exhibit 1 for purposes of this hearing, should the court wish to review it as well. I also gave defense a copy. I also further called the homicide unit to see if it was an open pending case with them, and they said it was, and I received the detective name, provided that to the defense counsel.
Okay.
So at this time, State would move to admit State's Exhibit S1 for the purposes of this hearing.
Any objection?
I reviewed it. I have a copy. No objection. And while you read, if I could just tell you the way it reads, it's a drive-by where it looks like they wait for one person to leave. That person is not Charlie. The person who is in front of Charlie who's leaving is a person who was shot. Just that looks like Charlie is behind him, so Charlie is shot also. So it's not as if they're trying to shoot Charlie. The target was someone else.
Could you all hand that to the court reporter, please? All right. So, State, does that change your offer or no? All right, then. And defense, your argument.
I know that a continuation where I left off. We're asking for probation, Judge. He doesn't want to be in the same neighborhood, the same area, the same association. He wants to clean, not necessarily for himself. It's for his son. He wants to be in a new city. We ask if you would grant probation 7 years. You can put the highest underlining sentence. He understands that if he messes up, he's looking at 7 years prison. He was reporting to parole. It's not as if he absconded and was picked up on this, and then there's a parole warrant. He was actually literally driving to his parole officer to report. He just finished a shift. He's going to make his appointments. He's going to appear on time. We ask you to grant the probation, and if he does get the residence changed with his mom and sister, we would ask probation transferred.
All right. I don't think you would be a good candidate for probation. The court is going to find you guilty. The court is going to sentence you to 2 years in the prison, give you credit for any time served. There's to be no unsupervised contact with minors, and there's a $0 fine, and the court will recommend the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Mama.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. So, Mr. Perkins, I understand that sometimes our life goes off track. Maybe we don't have great parents or something else. I understand when you leave prison, you're trying to do the right thing, but sometimes life gets in the way and beats you down. I know how difficult it is to get your license and to get legal documents when you just come from prison or just come from the foster care system. One of the reasons why I gave you the minimum is because of the shooting, right? And I understand that maybe you need to protect yourself or you feel you need to protect yourself, but I mean, you're not allowed to possess weapons, okay? So when you are released, please do better. And if you give me his case number, I'll ask that it run concurrent with the parole.
Yes, Judge. It's on the. Yes, I want to say.
Yes.
DC 2020 CR.
Wait, I'm sorry. DC.
2020.
Yes.
CR 537C.
8537C. All right, so this will run concurrent with 2020 CR 8537C.
If I may have one request.
Yes.
For his biological son, if the family does video visits, could the son?
Oh, no, it's just no unsupervised.
Okay.
Contact. So they can have any type of visitation. But I will tell you this, the day of that shooting, what time of day was that? See, you should have been with your son. All right. Make better decisions. Okay. All right. Good luck to you. And while you're in custody, try to get your GED. If you can't get your GED, there are plenty of opportunities if they allow you to do it. I don't know if they'll allow you to do it with your affiliations, but there are plenty of opportunities for picking up a trade. One of my former clients, mind you, they were in prison for murder. I ended up representing them on their parole hearings. And guess what? Their trade is welding. And you can make a lot of money at welding. Now he's got his life back on track. And you would think, you go to prison for murder, you can't come back from that, right? But he got all of his legal documents. And he also got his degree in trade certification in welding. And then somebody who just graduated not too long ago from felony drug court, criminal history. And guess what? People said it couldn't be done, but they are now an attorney and they handle civil rights issues. All right. So you still have a chance to be in your son's life, but don't bring this nonsense into your son's life. Okay. All right. Good luck to you.
Thank you, Judge.
You're welcome.
Have a seat, sir.
So that is how that ended yesterday, folks. And again, on Thursday, we'll be discussing that whole case for sidebar. If you weren't here yesterday, go back to yesterday's live show and check out this hearing. There's a lot going on, so that's why I showed the ending of it. Barbara, earlier, $5 super chat. Check out Second Session. Thank you for that, Barbara. Second Session being our news show today, 2:30 p.m. Eastern, 11:30 a.m. Pacific, right here on this channel. It is not morning live show, the sequel. It is a totally different format, and I encourage you to check it out. Let's go back to Michigan. Say good morning to Judge McNally.
Unmute, tell me your name, please.
Good morning. My name is Ashley Heskett.
Good morning, Trooper. Your name, please.
Good morning, Your Honor. Daniel McLaughlin.
Okay, so this is the time scheduled for informal. She's charged with 75 and 70. She's got a clean record here.
She's got a clean record and she meets the 33rd requirements. I'd be willing to amend it to impeding traffic, Your Honor.
Do you want to plead to impeding traffic, young lady?
Yes, I would. I would really appreciate that, actually. Thank you.
All right, to that charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'm going to accept your plea, dismiss the original charge. Fines and costs here are $150. You can go on 33court.com with your case number and make your payment, or you can come up here, whatever's easier, okay?
Okay, thank you so much. And
Best
thank you,
of
Trooper
luck.
McLaughlin. It won't happen
Thank
again.
you. Okay, Michael John Ford II, 2 6 7213778A. Mr. Ford, you can start your video and state your name, sir.
Michael Ford.
All right, so he's charged with limited access. Let me see what we got here. I don't have a traffic record on him for some reason. Yeah, there's not one in here. Lisa, can you run his record real quick? Or do you have access to it, Trooper, where you could tell me?
Yeah, give me just a moment, Your Honor. Let me,
Sure.
so I'm in a patrol car. It's a little easier than being on the motorcycle, so give me 1 second.
I can run it, Judge. It looks like he paid the B ticket and it was probably in there. It
Oh,
got
I
pulled.
see. Okay. You don't have it up, right, Trooper?
Not yet, Your Honor. I'm
It's
logging into the program now.
Okay.
mine's printing right now, Judge. Just give me one
Okay.
second.
Take your time.
Nope, he's got nothing.
Okay. And you paid the illegal window tint, correct, sir?
Yes, sir.
All right, so you got him going 85 and 70, you wrote him for 75, 70. What do you want to do on this one?
If he also meets the requirements of the 33rd, Your Honor, I'll also like to amend it to impeding traffic.
You want to plead to impeding traffic, sir?
Yes, sir. That's great. 'Cause, I've never had any tickets. I've tried to keep my record clean, so I'd like to, try to keep it as clean as possible.
All right, to the charge of impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea, dismiss the speed, 150. You can go on 33court.com and make your payment, okay?
Okay, can I have till Thursday to pay that, sir?
Yeah, I'll give you till the 7th, okay? August 7th is Friday.
Okay.
You just go on and pay by then, okay? Good luck.
All right, thank you, sir.
Stephen, Mate Wolf, 26. M724968. Stephen Wolf. Come on up to the podium if you would, please. So he's an Ohio resident. I don't have his either. Unless, yeah, it looks like he's got you got a clean record, right? Your name?
Stephen Wolf.
All right, so you got him going 89 and 70. You wrote him for limited access. What do you want to do on this one, Trooper?
Same applies, Your Honor. I'd like to, again, if it meets the stipulations of the 33rd, I'd like to amend it to impeding traffic.
You want to plead to impeding traffic, sir? Or do you want to have the hearing? Okay, just get it. Keep your foot. Okay, to that charge, responsible or not responsible?
Responsible.
I'll accept the plea, dismiss the original charge. 150 is your total. You can go right down the hump and pay that and you're all set. Good luck.
Thank you.
Evanoff. Thanks, Trooper. Have a great day. Douglas.
Your Honor, I got about
He
5
has
or 6
more.
more.
He's got a 9 o'clock.
Oh, they're at 9?
He has
Okay.
more for 8:45 too.
Yeah, pull the 845, gentlemen.
Yeah.
Douglas Jerome Evanoff, 260-716-103. Good morning, Mr. Bogart.
Good morning, Your Honor. David Bogart appearing on behalf of Mr. Evanoff, who's present standing to my left. Mr. Evanoff, please tell the court your full name.
Douglas J. Evanoff.
And Your Honor, we're here for an arraignment and a pretrial. For purposes of arraignment, we'd have to wait a formal reading of my final statement.
All right, I will enter a not guilty plea. Let me just see the complaint here. What do you want to say with respect to bond?
Your Honor, with respect to bond, Mr. Evanoff is gainfully employed. He is a Delaware citizen and been that his whole life. As soon as he received the letter, this is a date of incident. The alleged incident happened in January 12th of 26. As soon as he got the letter, he immediately contacted an attorney. We put in an appearance and we actually came here a couple of weeks back and first just to arrive at the court. He has no reason to flee the jurisdiction.
Who's Kenneth Evanoff?
Pardon?
Who's Kev? I'm talking to your lawyer.
That is his brother, Your Honor.
They don't live together, right?
They do not. And with all that said, Your Honor, we ask for a personal bond.
Does he have any record?
Your Honor, he had an attempted misdemeanor back in 2016. An attempted ADW. for the court's edification as well. As Lisa Court is well aware, there's been no conviction on this case, just like there's been no conviction on his brother. His brother also has charges against him by another brother, not my client, but the alleged victim in this case. There seems to be an issue with that. He is the Kenneth individual has a next hearing date in a couple of weeks under Judge Mertz Court 34. I report to at least understand that there's a couple of things that are happening with this person, Kenneth. So we would ask for a personal bond. They have not spoken or had any communication, Judge, since January of this incident.
All right, $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with the victim, Kenneth Evanoff. You cannot write, phone, see, text, email him, communicate with him, or have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses at all. Do not write, phone, see, text, email them. Except through your lawyer. Your lawyer can do that. No firearms, no dangerous weapons. You do have to go over and get fingerprinted and photographed today by 1 p.m. I filled out the order. Those are the bond conditions. We'll give you a new date and we'll set another pretrial. When are we going to do that, Lisa? The 18th?
Yes, August 18th at 9 o'clock.
Can we do the 25th? The 18th, I have a mediation with Mr. Bennett.
August the 25th at 8:30.
Thank you. Thank you, Judge.
Okay. August 25th, you can go down the hall, get your notice. We'll send over the order for prints and we'll give you a copy of the sheet. Okay.
Thank you.
Best of luck. Thanks. Have a good day.
Your staff have a good day.
It's TCF Live on a Tuesday. Good to have you all here. Let's go down to Florida. Say good morning to Wade Mercer.
Right, Daniel, one of these individuals has friends or family here, so let me call that case first. That's Zachary Ellenberg. Mr. Ellenberg, good morning. Mr. Ellenberg, your brother's in the courtroom on your behalf. He's not real happy with you, but he said he's going to talk about that later. You're here because you've been accused of one count of dangerous and excessive speeding. Mr. Ellenberg, I believe you have no prior criminal history at all. I'm going to appoint the public defender's office to represent you. Ask that you listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Edinburgh. He's going to accept the pretrial intervention from the state, pay a $928 fine while he's on the PTI, 6 months or we terminate. He'll take a 12-hour driver improvement class also, and he'll coordinate that with the probation office. That will resolve this case today, and I guess all we got, Your Honor.
Thank you very much, Mr. McDaniel. Mr. Ellenberg, did you hear that agreement?
Yes, sir.
That's our version of a first offender program. You have an Alabama address. They may call it first offender program up there. But anyway, it's a first offender program. And that is what you want to do, right?
Yes, sir.
Mr. Mitchell's had agreeable with the state.
It is, Your Honor.
Mr. Ellenberg, I'm going to show your case referred to the pretrial intervention program for dangerous and excessive speeding and second-degree misdemeanor. It'll be for 6 months. State law sets that fine high. It's a pretty new law. It's been in effect about a year. State law sets that fine at fine and court costs at $928. You'll also have a condition to successfully complete the advanced driver improvement course, the 12-hour version, and that course will be completed within 60 days, which will be October 4th. Mr. Ellenberg, as long as you do those things that the state's requiring of you and that you've agreed to do, the case against you will be dismissed. It is possible that they will dismiss the case early. A lot of times, if someone gets everything done at the halfway point, that's 3 months in your case. If you can get it all done, they'll go ahead and dismiss the case early. If you need the full 6 months, that's okay too. What's going to happen next is that you've got to be instructed by the probation officer, which is the same as the PTI officer. You'll be brought to the jail. The jail will bring you to the courthouse after you change clothes and use the phone. The reason to use the phone is if you need to set up transportation, they're going to let you get dressed in your regular clothes before they bring you. When you get here, you'll meet with Mr. Goodson or Mr. Ham, one of our PTI officers. They will explain the PTI with you. They'll give you a copy of all the rules in writing, and then you'll be free to leave. Yes, are you going to be able to pick him up, sir?
Yes, sir.
He'll be downstairs in 30 to 45 minutes in the county probation office on the east side of the courthouse. You don't have to worry about transportation. Your brother says he has that covered. Mr. Ellenberg, do you have any questions? Thank you.
Judge, I just wanted Jake to be aware now, he did have a possession of alcohol under 21 years of age, I think when he was 17 or 18 years old. I don't think it's gonna change anything, but I know that, it said nothing, but he did have something, but I don't think it was much. I don't think it's gonna change it, but I just wanna let you know.
Thank you. It's not showing up at all on your criminal history. Mr. Mitchell, does that make a change in the state's position?
That's juvenile in this situation.
Thank you. Mr. Ellenberg, the last thing I need to tell you is that every PTI comes with a conditional release. That's important because what the conditional release does is that gives teeth to the PTI. If you violate the PTI in a substantial way, such as not reporting in or getting a new criminal charge, if you violate, you can go to jail with no bond, just like you could on probation. You need to be aware of that. Does that change your mind about wanting to do the PTI?
No, sir.
All right, we'll see you at the courthouse in a little while. You'll be able to pick him up downstairs, okay? Have a good day, sir.
Thank you.
You too, sir. The only other case this morning is Christopher Lafert. Mr. Lafert, good morning. Mr. Lafert, you're here because you got 3 new charges in Jackson County and you have a hold out of Calhoun County. Let me start with that case. The Calhoun County hold is a child support matter that has a purge on it of $5,000. The Jackson County charges are trafficking in methamphetamine, first-degree felony, possession, drug paraphernalia, and operating without a motorcycle without the required endorsement. Those last 2 are misdemeanor criminal traffic charges. So you've got 1 very serious charge in Jackson County and 1 not so serious. 2 not so serious. I have taken a look at your criminal history. I see that you've been to prison twice, according to the Department of Corrections website. Most recently got out in April of last year. I don't see any active probation and I don't see any pending charges anywhere. That's good because that means you're entitled to a bond. So in just a second, I'm going to set you a bond. But before I set that bond, I'm going to listen. Actually, it's more complicated than that because the state has filed a motion this morning. So listen to Mr. McDaniel, then we'll listen to Mr. Mitchell and we'll go from there. Mr. McDaniel.
Your Honor, I've talked to Mr. Lafert too. We just asked for a reasonable bond, and I've also explained to him the NEBI motion that was filed to show the source of any income. If someone's about to come up, let us know, and we'll have a hearing on it if he makes the bond.
Thank you. Mr. Mitchell.
Yes, Your Honor. We're okay with a reasonable bond, given the circumstances, given his history, with the understanding that when the time comes to post a bond, that the NEBI motion be taken into effect, but nonetheless, we request that he have a condition of random UAs.
Thank you. So, Mr. Lafert, I'm going to set your bond at $50,000 on the trafficking charge, $2,500 each on the other 2 misdemeanor charges. Your total bond is $55,000, but you can't post that until the judge has a hearing. Either myself or Judge Garcia has a hearing regarding the source of the bond money. So you've got the right to a bond. If you're able to post a bond, you would contact the jail and say, can you get me back in front of Judge Garcia or Judge Mercer? And then we got to hear some testimony about where the money's coming from. That's the state has the right and the court has the right to know the source of bonds. And the state does this in virtually every trafficking case. Now they'll file this NEBI motion, which is what it's kind of called. So we'll see you if and when you think you can post bond. Let us know that and we'll go from there. The other thing is that if you do post bond at any point, you're going to have a condition random urinalysis because it's a drug offense that you're accused of. You're entitled to use the phone in a few minutes to contact friends or family for purposes of posting bond. The jail also, the staff out there is going to give you a notice for your court date, which I think is going to be September 1st. Yes. September 1st at 8:30 is going to be your arraignment date. But we may see you before then if you get the sources to post a bond. Do you have any questions? Nope. Have a good day, sir. Have a good day, sir.
Judge, I do have an update from or stuff I want to talk about regarding the case from yesterday.
Sure.
Okay.
So Rodney Hicks, I know that you said that Judge Garcia would take care of the bond revocation. I took the time to review the court minutes from yesterday. It doesn't mention whether or not she actually did revoke his bond in the felony case.
She said yesterday that she was going to deal with that today. So y'all can deal with it today.
Okay. All right. And That
He's
one,
got felony docket today.
yes, that didn't
Okay.
show up in the minutes, so that's why I just want to bring to your attention, but that'll take care of it.
Thank you. So y'all on the same page, corporate, y'all on the same page, right?
Yes, sir.
All right, good deal. Mr. McDaniel, we've got a scheduling issue on next year's calendar that Mr. Mitchell's got a conflict on. We're going to talk about, just won't take but about 2 minutes. But Corporal, anything else from the jail this morning?
No, Your Honor.
Mr. McDaniel, anything else we need to jail for first appearance purposes?
No, Your Honor.
And Mr. Mitchell, first appearance purposes?
For first appearance purposes, nothing, Your Honor.
Thank you.
Short morning for Judge Mercer. Let's go back up to Michigan, Nuevo County. This is Judge Springstead.
This is case number 24134888 FH, People versus Lance Jason Tresek. And Mr. Tresek is here for a probation violation hearing, represented by Ms. Frisbee. And there's been a report, including a recommendation. The recommendation is that on initial advisory guidelines of 2 to 17 months, the recommendation is that that in lieu of prison, that he be sent to TRICAP, that remain in custody in jail until TRICAP is able to provide direct transportation to the program. He would remain on probation. And Mr. Walburn, is that your understanding of the recommendation, and do you adopt that as an offer in this case?
We would adopt that as an offer in this case, Your Honor.
All right, Ms. Frisbee, is that your understanding of the offer?
It is, Your Honor.
And what does Mr. Tresek want to do?
I think we need to have a hearing, Your Honor.
We have a hearing?
Yes.
Good. All right, and Mr. Walburn?
We have Agent Grutter subpoenaed, Your Honor.
Raise your hand, please, sir. Do you solemnly swear, oath, or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. State your name for the record.
Zachary Grutter.
Your spelling last name.
Grutter.
Where are you employed?
Machine Department Corrections on Louisville County Probation.
How long have you been employed there?
Approximately 16.5 years.
Are you familiar with a Lance, I guess, Tresek? Tresek?
Yes.
How are you familiar with him?
He's on probation. He was supervising Kent County. I met him in the Nuevo County Jail prior to transferring down there.
How long has he been on probation with you?
I did his initial in the Nuevo County Jail on 1st of December. Started on February 4th of 25.
Did you file a petition, I guess, alleging he violated the terms of his probation?
Yes.
Have you become aware of something that allegedly happened on June 30th, 2026?
I did.
Was that the basis for the probation violation?
Yes.
Can you indicate to the court what information you obtained that led you to filing the violation?
Yep, it was a Kent County Sheriff's Office report based on some contact they had with him.
All right. What was the nature, I guess, what were the contents of the report that led you to file the violation?
It was initially a traffic stop that resulted in the officers finding some drug paraphernalia and methamphetamines.
What were the specifics, you know?
The specifics regarding
of the investigation?
Just that they found approximately half a gram of methamphetamine and a straw and some scale.
Was Mr. Tresek in the automobile?
He was.
Was there anyone else in the automobile?
There was a passenger in the vehicle.
Was methamphetamine located in the automobile?
It was.
Did the officer indicate in his report any observations he made about the defendant?
Just that while they were searching the vehicle, he did make a statement about there being them finding half a gram of methamphetamine in the vehicle.
You mentioned paraphernalia. What type of paraphernalia are you?
There was a tutor straw used to ingest via nasal.
Where was that located?
I believe that was in the center console in plain sight, which is why they search.
Did the deputy's report indicate any, I guess, physical observations that would lead one to believe the defendant was using methamphetamine?
They did note that he had redness around his right side nostril.
Were you able to talk to him about this, I guess, alleged violation?
I've not been able to talk to him.
Was that because he was appointed a lawyer down there?
That's right.
Do you know, was the suspected methamphetamine field tested?
It was, and it tested positive for methamphetamines.
I believe you referenced a potential way where the drugs weighed.
The officers did weigh it, and it was approximately half a gram.
This information you're testifying to, did you review that from a police report?
Yes, from
What agency was it?
Kent County Sheriff.
Sheriff's deputy. They brought a canine out?
They did.
It's violation of state law, a violation of his probation.
It is.
So I believe one of the allegations indicate a resist, obstruct an officer.
Yep, so originally, the agent in Kent County notified me that there were 2 charges pending. However, the resist and obstruct belongs to the passenger, not to 236.
That doesn't really pertain to Mr. Treese.
That does not pertain.
I think she gave a false name was basically that. Prior to Mr. Treese being on probation, and the rules of his probation, does someone go through those with him?
Yes.
And that was done in this instance?
It was.
Wow. Has he struggled with methamphetamine while you've had him on probation?
Per Kent County has supervised him for his duration of probation since he was released from jail. He has struggled to maintain sobriety. He has tested negative or positive for methamphetamines on a couple occasions, and struggled in a couple other ways as well.
Were those tests while you had him, or was Kent County supervised him at that time?
Kent County was supervising on this docket.
All right. I guess, when did you start supervising on this docket?
I've never actively supervised him. He's lived in Kent County this entirety of his term.
All right. Just for clarity, the case in Kent County was charged and then it was dismissed?
It was dismissed. I'm not sure why.
All right. That's all I have, Your Honor.
Questions, Ms. Frisbee?
Yes. You're saying that the Ariel does not pertain to this case, so that would be just like how it was dismissed, correct?
That's correct.
All right, so the possession of methamphetamine, are you aware that it was dismissed at a preliminary exam?
And I'm sorry?
Was it dismissed at the preliminary exam?
I'm not sure at which point it was dismissed.
You say he did not do well on probation regarding methamphetamine?
There were reports of him testing positive for methamphetamines in February and March of this year. No follow-up testing was done, unfortunately, but then he also had missed several report days that they had to try to locate him for.
And were you aware that he made calls and appeared the next day on some of those states?
That's possible in some of those cases. They were able to eventually locate him in all of them. No, he was never an absconder.
Were you aware that at least one of those tests was for methamphetamine was declared inconclusive?
I'm not aware of that.
Now, we provided you the information regarding that dismissal, correct?
That's correct.
And if you were to review your notes, would you just verify that it was dismissed at the preliminary exam?
It was dismissed in Kent County.
Thank you.
Any follow-up, Mr. Walden?
Just, the report indicated the defendant making a statement to the officer, what did you find, half a gram? And the officer's report indicated they also found a half a gram.
That's
of
correct.
methamphetamine.
Correct.
It was true narc as methamphetamine.
Yes, sir.
That's all I have, Your Honor.
Agent Grutter, do you know where this suspected methamphetamine was found within the vehicle?
It was reported that it was found on the floorboard in the front seat area.
Anywhere else?
Not that I'm aware.
I don't know if the floorboard was either on the driver's side or the passenger side.
I don't believe it's specified. The K9 unit did alert at the driver's side door scene.
I don't have any other questions.
I don't have other questions.
You follow up on that, Ms. Frisbee?
Where was the bag of methamphetamine found?
It wasn't a bag, it was just substances that were found on the floorboard, just
On which side?
approximately half a gram.
No, not how much.
I'm sorry.
Which side of the vehicle?
I'm unsure, it just said on the floorboard.
Thank you.
Anything else?
No.
All right. This witness step down.
Yes.
Any other witnesses that you wish to call, Mr. Waltman?
Not today, Your Honor.
Witnesses you wish to call, Ms. Frisbee?
No, Your Honor.
Good. Argument?
Your Honor, just this isn't a jury trial. The standard is not beyond a reasonable doubt. We'd argue that based on the legal standard by preponderance testimony of Agent Grutter to the circumstances around this, that it would support probation violation. He's clearly got methamphetamine in the car. He made utterances about the methamphetamine, the quantity. Based on the totality of the circumstances, we would argue that is a probation violation.
Yes, Your Honor. Well, I think there's arguing one mistake made on this regarding the RNO. I can tell you that the charge possession of methamphetamine was dismissed at the district court level. So it was dismissed with the, probable cause level, this being a higher level of proof here. I would say that the fact that he did not, he was charged, but they were dismissed. So it did not actually technically result in a violation of state law. And that following, the methamphetamine wasn't found on his side of the car, it was found on the passenger side. And that charge was dismissed. So I would say that these commission violation allegations are not valid at this point, and we would ask that this matter be dismissed. Thank you.
All right, the court does find that the prosecutor has met his burden of proof by a preponderance of the evidence in this case. Agent Grutter testified that he met with the defendant at the Nuevo County Jail, went over the terms and conditions of his probation, and one of his conditions was he not violate any criminal law of the state of Michigan. He also testified that possession of methamphetamine is a violation of state law. He then recounted information that he received in a police report from Kent County that the defendant was operating a motor vehicle subject to a traffic stop. K9 alerted for potential controlled substances on the driver's side of the car. There was methamphetamine found in the car, approximately half a gram. There was a straw used to ingest controlled substances found in the car, and the defendant's nostril appeared to be red on the right side, which is indicative of snorting controlled substances. Half a gram of controlled substances was gathered, and it did test positive for methamphetamine. the defendant had at least 2 failed drug tests for methamphetamine, although those were a few months before this alleged incident. The defendant did make a statement essentially asking the police, did you find a half a gram? In fact, the half a gram was found. So based on the totality of the circumstances, the court does find that the defendant violated his probation by possessing methamphetamine. Now, given the testimony, there was no testimony that there was testimony taken at the preliminary examination. It was just dismissed at the preliminary examination stage. So I don't know if there was testimony. I don't know if there was a lack of finding of probable cause, but I heard the testimony today, and regardless of what a judge may have found in Kent County, this is shown by preponderance of evidence. Also, there was no testimony or evidence in the proofs today indicating that the methamphetamine was found on the passenger side. The testimony was that it doesn't know where it was found. So the court does find that people have met their burden of proof. Now, there's been an updated report. Do the parties wish to proceed to sentencing today?
We would not object to that, Your Honor.
Fine, Your Honor.
All right. And was the report timely made available to the parties?
It was, Your Honor.
Yes, Your Honor.
Ms. Frisbee, have you had the opportunity to read the report and discuss it with your client?
He's had the, yes.
Do you have any additions, corrections, or challenges? Anything that you want the court to consider?
I would ask respectfully, Your Honor, that my client just be, I know in light of the recommendation, it's just retro TRICAP. It might be I wouldn't necessarily object to that, as opposed to being sent to prison or any additional incarceration.
All right. And Mr. Tresek, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
What report? Yeah, I mean, we went over it for a minute or something, but not.
Okay, that's fine, sir. If I can just reset your sentencing for a few weeks from now to give you plenty of time to read it.
I went in there, we sat down, talked about it, but.
Okay, we'll just set your sentencing date, sir. So when we come back again.
You're saying we talked about it, but it ain't.
No, sir, I asked you if you had the opportunity to read it.
Yeah,
You said we kind of sat down, we kind of chatted about it. You never said that you read it.
Yeah,
So I'm asking you, did you sit down and read the report?
Yeah, we read it. We read about over the violations, yeah.
Okay.
I was just using on what report you was talking about. You're talking about the police information, the violation report. We went over the violation yesterday. We went over the violation together yesterday.
And you previously reviewed the actual pre-sentence report that led up to your sentencing. You went over that at your sentencing, right?
Yes.
So you've read the pre-sentence report and you've read the probation violation report. Is that right?
Yeah, yeah.
Do you want more time to go over those with Ms. Frisbee?
No.
Do you have any additions, corrections, or challenges to the report?
Other than yes, no, reports.
All right. Is there anything that you want to say on your own behalf?
I reported, well, sometimes I couldn't make it down there in time or whatever, so I called my PO, let him know ahead of time, I couldn't get down there. He was already come on this day. I was going through the treatment process. I completed my substance, the inpatient. I was going through that. I was communicating with my PO, and then we got pulled over, or whatever. And,
they had me outside the car the whole time. I mean, I don't know what's going on around and in there, and so they said they found some things on the floorboard or whatever, but my understanding of it is, they said half a gram, well, he did that with the baggie on there. The baggie weighs about a half a gram, you know what I'm saying? I ain't disputing what's going on or this or that, I'm just to the facts of it, you know what I'm saying? I take responsibility for everything I do every time, you know, that's from last time I met you. And, I ain't the best candidate, you know what I'm saying, but I was trying to. I take responsibility from all my actions. And, of course, gonna do. And I hope that they show mercy on my sins, but I gotta, you know, my wife's 5 months pregnant, and I like to see that happen. You know, my new son, but I take responsibility for what the court's gonna give me, and I always have, and that's about it.
All right, Mr. Walburn, any additions, corrections, or challenges?
No, Your Honor.
Anything that you want the court to consider?
Just fresh report to the PSI, 11 prior felonies, 28 prior misdemeanors. He's on probation for controlled substance. You're aware he's continued to test positive for controlled substance. He does not look like someone who's going to stop using controlled substances. We'd ask the court craft a sentence that reflects those facts.
All right, so the court recognizes that the advisory guidelines would suggest a sentence between 2 and 17 months. The court's going to exercise my discretion since it's consistent with the advisory guidelines, consistent with the advisory guidelines. Be the sentence in the court that this defendant served 17 months on the minimum to a maximum of 4 years with the Michigan Department of Corrections. Give him credit for the 280 days that he served, 380 days that he served so far. Mr. Tresek, you know, at the time that we sent it you, that you indicated that you wanted help, you were on parole, the prosecutor wanted to send you to prison. I showed you mercy at that point and gave you county time with the opportunity to get day for day credit for any county jail time for an inpatient treatment program. Apparently you didn't take advantage of that for whatever reason. You couldn't have been out of jail very long, probably a few months before you started testing positive for methamphetamine. You were given the opportunity for outpatient treatment program, which you took advantage of, but you didn't learn anything from it. So then here we are back again, and my notes from the time of the sentencing is that my prediction was that you were not going to make it through probation, but at least I would have given you the opportunity to try and get some counsel. We gave you the opportunity, it didn't work, you're on parole, you're going back to prison, sir.
Your Honor, on the report, it indicates that my client has 379 days of credit.
Right, I misspoke, I said 280, then I corrected myself to say 380.
380?
380. All right, so Mr. Tresek, you do have the right to appeal this conviction sentence. If you cannot afford an attorney, the court appointed attorney represents you on the appeal. The request for lawyer must be filed with the court within 42 days.
Alrighty, friends, it is hour 2 now of TCF Live on this Tuesday morning. Thank you all for joining me today. Let's go to Texas, check in with Judge West.
Good morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. We're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure.
Okay, I'll be sure to add it. Mr. McWade, in cause number 26, DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted aggravated assault with a deadly weapon from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them? Yes or no? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry, there would be an 8-year term in prison that would be
Which
probated
I
for 8
believe we can
years.
do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
A
a little bit?
little bit, yes, Your Honor. That's
Okay.
my understanding.
All right. So what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed to.
It's in that big green book, I think.
I'm sorry?
It's in that big green book.
Yeah.
The big green book.
The big green book. All right, so it looks like the agreement is for you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a
Saw
restitution.
the word
center.
restitution and checked the box.
So there's an agreement, I'm gonna write that you would pay restitution, is that correct? And the amount determined between now and sentencing?
Yes, Sean.
Is that, you understand that as well? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount. And we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
Your Honor, he served 150 days in jail. For this case, we don't propose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway, you can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Let's make it.
Could you please make a note? Because I feel like I'll probably be on that. Take some of all the emotions. Your name, I'm guessing, Ariel. Would you like to remind me, and I can ask Ken to help me out with that? Yeah, give me 1 second. What you got?
I'm in trial next door.
Okay.
And we're getting ready to get started in a minute. And I think Tommy has some redacted stuff for me to look at. So I need to get over there.
Okay.
But
I see that with a lot of them.
I know the pretrial case that I had that's on the trial docket. Josh Smith.
Okay. Yes.
Mr. Smith just gave me a new offer that's gonna resolve that matter. I just
Okay.
need the time to do paperwork and everything to get it done. It's gonna be a probation plea.
Okay.
I don't know if I'll be done today, but if we can do it if there's some available next week.
Well, no, well, we could do it Wednesday of next week. Or we could do it early tomorrow. No. Let's set it for a plea Wednesday morning of next week. Yes. Joshua Smith, well, So all of Mr. Lewis's are reset now. Okay.
Sorry about that.
That's okay. We could have not brought them all over, which we've known. Okay, but that's fine. All right, so I will set that one though for a plea on Wednesday morning. Yes, sir. Well, that just, no.
All right, looks like it's going to take her a few minutes to find the next contestants. Let's go back up to Michigan, Otsego County, where justice is best served in a converted pole barn. This is Judge Hunter.
To go through the PSI. You need more time to go over it. Mr. Dick, on behalf of Ms. Olson, do you have any corrections, additions, or deletions?
Your Honor, on the very first page of the PSI, CFJ 101, page 1, in religion, it says Christian Science. We would ask that the court removes the word science because it is a different type of.
Any objection to that change? No. Any other corrections, additions, or deletions?
Secondly, Your Honor, CFJ 145, page 1, on the third page of the packet. Under the agreement, just underneath the box, the second line down, it says count 1, 3, and 4 will be dismissed. That particular provision should be removed or deleted.
It would be down to a 1-year misdemeanor, 200 to 1,000 if she pays the $25,804, correct?
No, Your Honor, it's still an attempt, but let me redo the word after. So it says she pled guilty to count 2 embezzlement. Under the plea agreement, she pays $25,804.75 restitution during the 1-year delay. The charge will be reduced to attempt. Counts 1, 3, and 4 should be dismissed this time.
They're being dismissed already.
Yes.
Correct. So 1, 3, and 4 are already being dismissed on the plea agreement, correct?
Yes, Judge. So essentially the intent here is not to make the delay the reason why those counts are dismissed. The intention is that she pled to the count, but if she successfully completes the delay by paying that amount of restitution of the total amount, then it would be reduced to an attempt.
Well, that's what was confusing to the court because unfortunately my notes were not as clear as I was hoping they were either. I usually take notes during plea hearings. My initial notes from June, when I didn't accept the plea, there was a suggestion that there may be a reduction to a misdemeanor. Was that not the case at the time of the plea entry back in July last month?
It was not.
All right, so it was only the attempt would be a reduction to attempt if there's at least that $25,804.75 paid during the 1-year delay. Yes. And then there was also some language in the PSI about if a third of the total restitution was paid, reducing to an attempt. What say the attorneys about that?
So Judge, yeah, that one, it should actually, I guess the way we phrased it was that she pleads to the charge, and if she pays 2/3 of the restitution, which is the $25,804.75 during the 1-year delay, then the charge is reduced to an attempt.
And that's it?
That's it.
Okay, is that correct?
Yes, sir.
All right, so the court's going to update the PSI to reflect that dismissal of counts 1, 3, and 4. It's a plea as charged to count 2, reduced to an attempt if at least $25,804.75 is paid within the 1-year delay. Otherwise, sentencing on the original offense, the 5-year max. Correct?
Yes, sir.
Yes.
All right, so I'll make sure the PSI is clarified to indicate that. That would mean just dismissal of all of the language regarding 1/3 of total restitution paid. Any other corrections, additions, or deletions to the body of the report?
Your Honor, CFJ 284, page 1, it has the same language that we just reviewed.
So we'll make the same consistent language throughout the PSI.
Yes, sir.
Any other corrections, additions, or deletions?
No, Your Honor.
Are the guidelines accurately scored in this case?
They are.
Mr. Fortier, do you have a victim that wants to allocute?
I do not, Your Honor. However, Ms. Weaver, the office manager, is here. She's here on behalf of Dr. Fuller. She's not technically the victim in the matter, but she is here essentially just watching to see what happens. So she can go back to
All right, and that's perfectly acceptable. I also would note I did receive a copy of a victim's impact statement from Michelle Weaver, also by Brian Weber and Jill Peach, who signed all three of those individuals. Did each of the attorneys receive that letter?
Yes, sir.
Yes, I see.
All right, and so the court would note that, well, do you have any corrections, additions, or deletions on behalf of the people?
No, Your Honor, aside from the ones that we've already discussed, that was.
Do you believe the guidelines at 0 to 6 is accurate?
I do.
And do you have allocation on behalf of the people?
I do, Your Honor. So essentially, Ms. Olson was placed in a position of trust, and she violated that trust when she took the money from the accounts that belonged to her place of employment. Not only did she violate the trust of the business, she violated the trust of Dr. Fuller. She violated the trust of her fellow employees. I think it's very hard to underscore how hard it's going to be for her in the future to regain that trust. Because this one, I mean, it's not a violent offense, but the way I would think of it is it's an offensive offense in the sense that you're taking, money of a business that trusts you to handle its affairs, and you completely just violate every single, belief that they had in you to do your job on their behalf. I think it's the benefit of the plea agreement is that hopefully Dr. Fuller is repaid to the extent that this gets paid during the time. That's the most important part in cases like this, is just making sure that the victim's made whole, especially when there's a significant amount of financial loss. I mean, $25,000 isn't a small amount of money, and I recognize that it's probably going to be a struggle for Ms. Olson to pay that, but ultimately that's her responsibility. She pled to it. She owned her mistake, and I asked the court to continue to hold her accountable. Put her on that 1 year period, give her a chance to pay back that money, and hopefully make Dr. Fuller is full or completely whole as possible. And if she is successful in that, she would still have a felony on her record, but at least it would be an attempt to whatever effect that has on the future. Futures consideration. Again, the restitution is just the most significant thing that we're concerned about here. Just making sure that she doesn't violate the trust of anyone else in the future.
Thank you, Mr. Dick.
Yes, Your Honor. I want to start this by just saying that Ms. Olson, she does feel quite ashamed of what she did. She does find herself in a predicament where she had a long-term position with the business where she did take the money from. They were essentially her family. And well, she's broken the trust of that family. She's no longer employed with that employer. She's since sought out other employment and is now gainfully employed. However, not only the work family that she had, that she no longer does, she's been dealing with marital issues arising because of this offense. Your Honor, all of this arose during a time of financial distress for Ms. Olson and her husband. In her downtime, when she was not finding herself busy, idle hands found her playing on the online Michigan lottery. She did at one point have a decent win, and I'm going to kind of relate this to some people can't drink. Some people tried drugs once and they are now addicted. Some people have other issues. Your Honor, that is what happened here. This was a system, gambling, which is designed to hook its players or its users. It worked. It worked. Miss Olson is ashamed that it worked on her. However, it did. As her financial struggles got worse, she was trying to dig herself out of a hole, surrounded by nothing but sand. And when you know what sand does as you're trying to go uphill, it's kind of like trying to climb up the dunes. It just keeps coming down. That is where she found herself. Your Honor, she attempted a number of times to speak with her employer about what she has done, but she could never find the voice just because of the shame that she felt. Since this time, Your Honor, she has disclosed this to her new employers, both of them. One of them is even assisting her to get into counseling services, specifically to deal with the gambling addiction and the other underlying mental health issues that she may have from her younger years. That being said, Your Honor, it's still no excuse to take somebody else's money. And she's standing here today because she owns up to it. And she does intend to work her fingers to the bone to make sure that she does repay this money. With that being said, Your Honor, we just ask that the court hears what Mr. Fortier said. These matters are generally most important to have the victim reimbursed or the restitution repaid for these matters. Ms. Olson has been punished since the first time that she did do this, and she will continue to be punished for this for the rest of her life. With that, Your Honor, we are asking that the court just extends the delay.
Thank you. Ms. Olson, is there anything you want to tell me before I close sentence? I'm glad that at least your attorney has explained, Ms. Olson, that you feel a great deal of shame regarding these circumstances, because these are shameful actions. It's not excusable in any way, and it doesn't make it better when you steal from other people, but it certainly makes it worse when you steal from people that you consider family and they consider you family. And it certainly makes it worse when the amount of money you stole was nearing $40,000 over a period of many years. This was a planned system of taking advantage. And while your attorney may have been able to argue, it might be supported in the record that it was based upon a gambling addiction, the facts otherwise don't change. You stole from people who trusted you. They forever are changed now because of that. They look at people differently. They trust people less. Not just you, who has earned the wrath of their distrust. They look at other people in the community differently. Their lives and their view on humanity is forever changed because of your thieving. So I want to be clear about what this is and what this is not. I agree to delayed sentences in circumstances like this because I agree with the attorney's suggestion that the primary goal, is you paying back money that you stole. That's not the only goal. And a delayed sentence is just that. It's delaying what is going to be inevitable, which is your payment or lack of payment of the substantial monies that you stole from people who you claimed to love and claimed to love you is going to affect most sincerely how I view the case when we get to the end period of the delay. In other words, the more that you have paid towards that total amount, $25,000, the less likely I'm going to feel compelled to be overly punitive. But to say that on the other hand, if we get here in a year from now and you've not made any reasonable payments on restitution for all of the money that you stole, I'm going to feel compelled more than likely to send a punitive message to you, because a delayed sentence will be done there, and I'll be imposing sentence on a 4-year felony, which encompasses you stealing almost $40,000 from your long-term employer and person of trust. So I want that to be abundantly clear. Again, to the extent you're able to pay all of the restitution, that will significantly impact my view on whether or not punitive sanctions are further necessary. Because your attorney is right, that in some ways, the sanction that you've received already, the fact that you have a felony conviction is going to be significant. The fact that you're ostracized in the community is significant, and I think to a good point. The fact that you're going to be labeled as and have on your record eventually an embezzlement is significant. And I hope that it is, because it's a significant action that you took over a period of years. So all of those things to say that I'm going to grant a delay, but your participation in payment of significant restitution will be the difference between whether or not I look at this case as one that ends in 12 months as a punitive sanction, or one that ends with different type of action. Only your payment of restitution, not only, but primarily that would be the difference maker. So I will put you on a period of probation under a 1-year delayed sentence under 771.1. That is for a period of 1 year. I'm going to have my staff set a sentencing date approximately 1 year from today. So it'll be August of 2027. That will be an in-person proceeding as well. If you pay at least $25,000, $804.75 in that period between now and next August, you'll be entitled to an attempt, which will have the effect of reducing your guidelines range and maximum overall exposure. If you don't, you won't have that benefit. You face the maximum punishment that I could give you. The guidelines are 0 to 6, but as course, as I'm sure your attorney has explained to you, those guidelines are not binding upon the court. They're advisory. So I'll take them into account, but they're not binding upon me. I will order that you otherwise pay the fines and costs that were suggested, which includes the $30 supervision fee per month, $130 fine and assessment, court costs of $325, attorney's fees of $350, DNA testing of $60, and a $68 state cost. Those fines, costs, and assessments are all due today. If you don't pay them within 56 days of today's date, a 20% late fee does get added on. You do not have any appeal rights right now because you're on a delayed sentence. If at any time I revoke the delay because I hear that you're violating the law, not making reasonable payments, then at that time you have the ability to appeal, and I'll provide you those appeal rights. Do you have any questions regarding the court's order? No. Check in with probation before you leave to sign that delayed sentence probation order. Mr. Dick, anything else today?
No, Your Honor.
Mr. Fulcher, anything else today?
Nothing further, Your Honor. Thank you.
You're all set. Check in with probation before you leave.
Halfway through TCF Live now. Barbara gave us $5 requesting prayers for Nancy. For those of you who aren't familiar, Nancy is a regular around here. It sounds like her husband is having some difficulties this morning. So those of you of faith, let's go ahead and lift them up. Let's go to Michigan. Judge McNally looks like he's doing an examination. If I heard it correctly, it's on a DWI case.
Aaron, you have yours? Yes, Aaron Lavelle.
All right, you can have a seat, sir. So we're going to proceed to exam on this, correct?
Yes.
The charge is OWI 3. Let me just double check the complaint here real quick. Yeah, we got an operating while intoxicated. Third offense, and a drive while suspended, revoked, denied. So the only thing we're going to have the exam on is the operating while intoxicated. Any preliminary matters?
One preliminary matter, Your Honor. My understanding the defense counsel has stipulated the MSP lab report that showed the defendant's blood alcohol results at 0.136 grams of alcohol per 100 milliliters of blood.
All right,
For exam purposes only.
are you going to have the toxicology report marked and received, or?
I do have the report.
You don't have to if you don't want to, as long as you guys stipulate to the blood draw.
We stipulate.
Okay, so for exam purposes, the court will consider that the lab report indicates the defendant had 0.136 blood alcohol level when the blood draw was performed on January the 1st, correct, at 26?
That's correct.
Any other preliminary matters? Any from the defense?
No, Your Honor.
All right, you can call your first witness.
Officer Ariel.
Okay, come on up here, sir. And I will ask you to raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
I do.
Okay, have a seat. You can proceed.
Thank you, Your Honor. And good morning, Officer McArdle. Officer, can you tell us where you're employed?
Flower Police Department.
And what do you do in the police department?
I patrol the city
Okay, how long have you been in office for?
approximately a year now.
Okay, were you employed as an officer on January 1st, 2026?
Yes, ma'am.
Okay, and what date is January 1st, 2026?
Sorry, what was that?
Were you working on January 1st, 2026?
Yes.
Okay, what were you doing? Well, what were you assigned to do that day?
Patrol the streets, make sure that everyone's on track laws and
And then were you at near Arsenal Road in Rockbridge Court?
yes,
Is that in the city of Flower County of Wayne?
yes, ma'am.
Okay, why were you in that area?
Because I was a police officer for Flower.
I'm just gonna ask you to pull in a little bit and just keep your voice up nice and loud for me, okay?
Did you observe anything while on that road?
Yes.
What did you observe?
In front of 26-800 Arsenal Street. I was traveling northbound on Arsenal Road. And I observed a blue Ford Explorer. And what appeared to be the front yard in front of that address, a blue Ford Explorer that was running. It was occupied. There was smoke coming from the exhaust. That's what I observed.
Okay, why was that significant to you, or why did that flag your attention?
I saw tire tracks going into a driveway. And then there was just a vehicle off to the left of those tire tracks inside of the front yard in front of the residence, which was 26800.
What did you do after you observed Dustin?
I approached the vehicle and I observed our suspect in the driver's seat with the lights illuminated on the dash and the vehicle would be running. It wasn't in park. So I knocked on the window multiple times, checking.
Were you able to observe whether that vehicle was in park before you approached the window?
Yes.
Okay, how long was it not in park for?
I didn't answer that.
Okay, and then why is it that you decided to approach the driver's side window or the car in general?
It was weird for me to see a vehicle parked in a front yard, not pulled into the driveway. It was very late at night. I can't recall the exact time.
Okay, late at night, was it into the AM?
End of the day.
Okay, and then, you stated that the vehicle was occupied. How many individuals were in the vehicle?
One individual.
Would you recognize that individual if you saw them here today?
I do.
Could you take a look around the boardroom and point out and identify a piece of clothing they are wearing?
Gray, collar shirt.
You're on this time, the record of going to look at Mr. Odom.
The record should so reflect.
Thank you. And, what happened when you approached Mr. Odom?
Knocked on the driver's side window multiple times. He appeared to be sleeping in the front seat. He would not answer to me. I announced myself as Officer McCardle with the Flatiron Police multiple times, pounding on the window, trying to get him to wake up. I wasn't sure if it was a medical issue, wasn't sure what was going on. And eventually, after knocking and announcing on the window multiple times, he woke up and rolled down the window and spoke with me.
Okay, when he rolled the window down, what anything did you?
He seemed very disoriented. He had slurred speech. He could barely hold his eyes open. His eyes were bloodshot and watery.
Okay, what are those indicative of to you?
Intoxicated driving.
Okay, do you have any training and experience in, drivers who could potentially be intoxicated or under the influence?
I did.
And what is that?
I had OWI training throughout my academy that I did receive certification for.
Okay, and then, what did you do based on your observations?
I spoke with him. I asked him for his driver's license, which he fumbled his cards around, and it took him a little bit to find it, but he did eventually find his license. After observing what I observed, I asked him to step out of the vehicle because I had observed that he was intoxicated.
Okay. Did you smell anything?
I did. I had a strong odor of intoxicants coming from his lips.
Okay, and after you stepped out of the vehicle, what did you do?
I conducted SMS tests. I asked him all the medical questions. I stated he wasn't a diabetic.
Which tests did you conduct?
I conducted horizontal gauge nystagmus, walk and turn, and was already seen.
Okay, and then was Mr. Lobel able to complete each one of these tests? Did he agree to completing these tests?
He agreed to.
You started with the horizontal gaze and stag's test.
Yes, I did.
Could you just provide a brief description of that test?
Yep. Would you like me to?
Just a brief description of what you're supposed to do.
Okay, what I do, I hold the stimulus to about approximately or between 12 and 15 inches in front of the face and move it left to right, pausing at some points.
And did you give Mr. Lavelle directions to how to complete this test?
Yes, I did.
Okay, and did he perform this test?
Yes, I did.
And then did you make any observations while he performed this test?
Yes, I did.
What observations did you make?
He had, the nystagmus at maximum deviation. He had nystagmus prior to 45 degrees. That's all I can recall.
Okay, and what is it that means?
It will show the eyes bouncing. And that will show.
Really, let me check, John, he's not been, he's not testifying as an expert, he says as a police officer, and he's giving expert testimony right now.
Judge, I don't believe the was testifying that the defendant's eyes were bouncing or is expert.
Yeah, I don't either. Overruled. You can continue your answer, sir.
Give me a second.
You stated that his eyes were bouncing, and then what else did you observe?
That just indicates intoxication for us.
Okay, and then you stated that there was no more tests. What was the second test that you had Mr. Lavelle perform?
The walking turn test.
Okay, and could you provide what direction did you give Mr. Lavelle?
I got him into the starting position, and I asked him to stay in that position until I demonstrated the test for him, which I did do. While I was demonstrating the test, he could not maintain the starting position.
You could not maintain what?
He couldn't maintain the starting position.
Okay. Did you provide us direction as to how, you stated that you didn't provide direction as to how to complete it. Do you know if Mr. Lavelle understood how to complete this test?
I did ask him if he understood.
Did he state that he did?
Yes.
Okay, what observations did you make? You stated that he wasn't able to stand at the starting point. What else, if anything?
Correct. While he was doing his portion of the test, he failed to touch heel and toe, and he didn't count his steps out loud.
Okay. And do you know if Mr. Lavelle had any medical issues or anything? Did you ask whether he had anything that could hinder his performance on that test?
Yes, I did. I asked him if he was a diabetic. He said he wasn't a diabetic. So I also asked him if he had any issues with walking or anything that would hinder him from participating in the test. He stated that he did not.
Okay. And then the observations that you made during this walk and turn test, what were those indicative of to you?
Investigation.
Okay. And you stated there was a third test as well. What was the third test that you performed or had Mr. Lavelle perform?
The one with the sand.
Okay. And then what direction did you provide?
I demonstrated the test, and so I got him in starting position as well. And then I demonstrated the test for him, and after demonstrating the test, I asked him if he understood, which he said that it.
Okay. And then was Mr. Lavelle able to successfully perform this test?
Sorry.
Was Mr. Lavelle able to successfully perform this test?
He participated in the test. I observed that he was swaying and he could not maintain his balance on the low.
And what is that kind of?
Oxidation.
And then, based on these, standardized field sobriety tests, what if anything did you do after that?
I offered him a PBT, to which he refused. And then I placed him in double locking handcuffs and replaced him in my patrol vehicle.
Okay, was Mr. Lavelle placed under arrest?
Yes, he was.
And what was he placed under arrest for?
OWI.
Okay, and do you know if there was a blood draw?
It was a blood draw.
Okay, was there a search warrant for this blood?
There was a search
Okay, and then, where did the blood draw take place?
at Fort Wiltern.
Okay, was Mr. Lavelle, was he then, transported to Orwell?
Yes, ma'am.
Okay, and then, did you observe, Mr. Lavelle's blood being drawn?
I did.
And then did you do anything else following that?
Yes, the sticker was placed on the blood kit box. I initialed it, and then we sent it off to the lab.
Okay.
And I believe that the nurse also initialed.
Okay, and then was Mr. Lavelle taken back to the police department after that?
Yes, ma'am.
Okay, and did you have any other involvement following that?
I didn't.
Okay. Okay, so it's kind of stay.
Ross?
Yes, Sean. Can I have the password for the internet, for the Wi-Fi, excuse me? Briefing. RB. This. Alright, so I'm trying to leave. On the night you pulled, it was January first, is that correct? Or morning of January first? Did you have any reports of any erratic driving or anyone driving in a crazy manner or some sort of indication someone was driving drunk that night?
I did not.
So you came upon Mr. Lavelle's car just in your normal course of patrol in the city?
Correct.
It wasn't driving, it wasn't on a public road, correct?
Correct.
And you had, again, there was no indications, there were any smart marks in the street you observed?
Not at the time. Not that I can keep on.
And do you have your report with you?
I did.
Did you write that report?
I did write the report.
Are you familiar with what the report says?
Yes.
At some point in that report, did you indicate that Mr. Lavelle's car was found in a ditch?
I did.
Okay. I showed you a video earlier. You still believe the car was in a ditch?
I would call it a ditch.
Okay. And so I'm setting the parts of connecting to the Wi-Fi. I'm going to shoot a video. Now you took a video that was taken that was with your body camera, is that correct?
Correct.
And as far as you're concerned, the night the body camera was on, that was working properly, correct?
Correct.
And you don't know of any issues with it?
Nope.
And it's a fair, as far as you know, that's a fair indication of what was happening that evening, right? Right? Fair record of it?
Yes, sir.
Any questions, Sean?
Yes, you may.
You want to see it first? I've seen it. So, you see where the car is, correct?
Correct.
And you'll agree on the left side of the car, there's a ditch there, correct?
Correct.
Car's not in that ditch, is it?
Wait a second.
Do you want me to be share your screen so we don't?
Yeah, I'm having a hard time doing it.
Oh, are you on Zoom?
Was, my internet's not connected for any reason.
Oh, okay.
Let me call Shane. Please, and let's go off, right, yeah, let's go off the record. We'll call,
Sends it to me, I can screen share.
Is it a Mac?
I'm sorry, Lisa,
If he sends it to me, I can screen share.
you want to send it to Lisa at 33court.com?
Well, that's a good shot on that house. But may I grab my laptop?
Sorry,
May I grab my laptop? It could work on mine because I shared videos. and
whatever you guys want to do. Look, I'll just get off the bench here.
Okay.
You figure it out and I'll come back, okay? Stay seated, everybody.
Okie dokie. Here's what we're going to do. Obviously, we have to move to another court because he is stepping off the bench. But what I want to know from you guys, and I'm putting up a poll now, is do you want to come back to this hearing when it continues? So we're going to put up a poll for that, and then we'll move on. All right, that poll is up. Let me know. In the meantime, let's go to Louisiana. Check in with the board.
Good morning. The committee on parole is called to order. Today's date is August 4th, 2026. My name is Chuck Tillis, and I'll be serving as chair today. My colleagues today on panel are on by Zoom, Ms. Jerry Ledoux and Mr. Steve Prater. The panel is located at the DOC office in Baton Rouge, Louisiana. Staff, would you introduce yourselves for the records, please? Our remote location today is at the Calcasieu Parish Center. Is there any staff there? You're on mute. Have them put you off mute, please. Can the staff there introduce themselves?
Staff?
Say again?
Yes, sir. This is Deputy Long.
Okay, thank you. Do you have a questionnaire with you, Mr. Humphrey?
Say that again, sorry.
I was asking Mr. Humphrey if he have a questionnaire.
No, sir.
No.
Okay, can we put it up? Okay, would you state your name and DOC number for the record?
Jaquez Humphrey, 630-493.
Okay. And you got it, Jess? Is that your signature?
Yes, sir.
Okay. You're not eligible for counsel, so do you wish to proceed with these hearings?
Yes, sir.
Okay, Mr. Prater has your case today, and we're going to ask Mr. Prater to go ahead and start, please.
All right. Yes, sir. Mr. Humphrey, how are you doing today?
Doing wonderful. How you doing today?
Doing good, doing good. And you're charged with a misdemeanor.
Yes, sir.
Battery, correct?
Yes, sir.
Okay. And how long have you been held on this charge?
I've been incarcerated since Memorial Day.
Since Memorial Day?
Yes, sir.
Okay. And let's see. Let me check and see who all is going to be talking today. Is the victim going to be talking to us today?
No, sir.
Okay, just you then, huh?
Yes, sir. Because I got the paperwork late and I didn't know the website that they go to, so I couldn't give it to him.
Okay. And when do you have trial? You've got a trial coming up, Bill, don't you?
Yes, sir. Next Thursday.
And on Thursday?
Next Thursday, on the 13th.
13th?
Yes,
okay. That's what I was thinking. I sure wish we were past the 13th. Are you ready for this revocation hearing?
Yes, sir.
Okay. Well, tell me about what happened.
Me and my fiance, we got a little altercation. She started beating me up, and I just grabbed her. That's the only thing I did. I just grabbed her and put her against the wall.
You grabbed her and put her against the wall?
Yes, sir. She just beat me up because I was trying to go meet another woman when I shouldn't have.
Why did you do that? What were y'all fighting about?
Me trying to leave and go meet another girl.
Okay. What class offender are you?
Second, sir.
Okay, because you're on parole for some pretty serious charges, aren't you?
Yes, sir.
Well, don't you know better than to be putting your hands on somebody?
Yes, sir. Yes, sir.
So you, let me make sure you're charged with violating condition number 4 of your parole. And number 4 says you'll stay out of trouble.
Yes,
And
sir.
like we said before, you were arrested while you were on parole, so that means you did get in trouble, at least enough to where the police thought you were in trouble. And I need to know, are you guilty of what they charged you with?
No, sir.
But you are guilty of putting your hands on her and throwing her against a wall, correct?
Yes, sir.
Okay. And, okay. Let me look, see what other questions I might have of you, and then we'll. How much time are you looking at?
I have 2 years left on parole.
2 years left?
Yes, sir. I get out May 23rd or 25th of 2028. And these charges will be dropped when I go to court.
Okay, she had some pretty serious evidence that she had been slapped around in the face.
Well, these charges finna be dropped. She signed the affidavit. I did not slap her in the face. The only thing I did was just grab her and stop her from hitting me.
Keep her from hitting you?
Yes, sir.
Why didn't you just leave?
That's what I was trying to do. I was trying to leave.
But according to her statement, that wasn't the case.
Like I said before, she signed the affidavit. She don't want to pursue with this. I did not do that. I grabbed her. That's the only thing I did.
Okay. All right. Check one more thing here.
Yes, sir. Since I've been here, I have 40 certificates that I have. I have 40 certificates. I completed 40 classes on the my cyphers work program.
Okay, I don't have any other questions. I'll turn it over to my board members there, Mr. Chairman.
Yes, sir.
One other violation you have is number 10. Mr. Prater.
Okay. All right. What about the fact that you owe money on your fees?
I wasn't working or anything.
Okay. Do you know how much you owe?
Like 1,100 or something like that.
Okay. All right. I just wondered if you knew. It's all in the record here.
Yes, sir.
Okay. I don't have any other questions.
Mr. Ledoux, do you have any other questions?
Yeah, I'm wondering, you got out in 2024. You haven't worked since 2024. What have you been doing?
I had messed my foot up.
So how have you been living?
She been taking care of me mainly. My wife been taking care of me mainly.
Wait, your wife was taking care of you?
Yes, ma'am.
And it was your girlfriend that you beat up?
Yeah, that's my wife.
It's your wife?
Ma'am. They're all the same person.
Okay.
I had messed my foot up and like the end of 25, I had messed my foot up real bad. I had split between my toe and I wasn't able to work.
The end of 25, you got out in September. So from September of 24 to the end of 25, you never worked?
No, ma'am. I had started working like around I want to say June or like October. Between that time right there, 25, I started working. And like November, I messed my foot up.
Okay. In your preliminary hearing, you pled guilty to that. You actually were sentenced for 90 days for the part of it, right? And you still have the trial for the other part? Let me see.
Yes, ma'am. I have a trial on August 13th.
Yeah. Okay.
I don't have any other questions. Thank you.
Yes, ma'am.
Mr. Humphrey, what do you plan to do if you're released?
Sir?
What do you plan to do if you're released? Are you capable of going back to work?
Yes, I'm ready to go back to work right now. My brother is waiting on me at the Golden Nugget. He's the supervisor at Golden Nugget over the banquet, and he's going to get me on at the banquet whenever I come home. So I have a job whenever I go home for sure.
Where will you be living?
I'll be going back home to my family, sir.
Okay. Is the panel,
2211 Elaine Street.
say again?
2211 Elaine Street, Lake Charles, Louisiana.
Okay. Is the panel ready to vote?
Well, let me ask you one thing. Why isn't your wife, your girlfriend wife, why isn't she on Zoom with us now?
Because I got the paperwork late. It just came to my tablet last night, and I didn't know what the link was. So I wasn't able to give it to her because the phones went off last night.
So you didn't know the hearing was today?
I knew the hearing was today, but I didn't have the information, sir, to give to her. For her to log into the Zoom thing, I didn't have the information. We don't get the paperwork directly in our hand. We have to wait until the woman come around and scan it. And she just came yesterday evening. And the thing ain't come to my tablet till like later on that night.
Okay, I don't have any other questions.
Yes, sir.
Mr. Prater, you're ready to vote?
Yes, sir. I believe that you need some anger management or domestic violence training.
Yes,
and
sir.
I think the best people equipped for doing that would be the Department of Correction. So my vote is that you be revoked and sent to a facility that offers both anger management and domestic violence courses.
Ms. Ledoux?
My vote is to revoke today based on his admission of guilt that he committed violence against his wife, and I would concur with Mr. Prater about his programming.
Okay, my vote also is to concur with my colleagues, Mr. Humphrey, to see that you probably get some classes of anger management before you are released. This will end our business today at the Calfish.
Hour 3 of TCF Live on this glorious Tuesday. It is good to have you with me. Barbara gifts 5 memberships. Thank you very much, Barbara. I appreciate that. Welcome to new members. 71% of you voted to go back to the McNally hearing. I have no idea what just happened with that parole board hearing because I wasn't listening, so you're all going to have to catch me up to speed because I've been trying to figure out the McNally thing. It is back up and running. They have body cam and they're clearly showing it, and I think I'm picking this up in the right spot. If not, we'll figure it out, but here we go.
Stay seated, please.
Over the back side.
All right. Go back on record. All right, we're back on record. LaBelle, you can proceed.
Just like it was. When you're coming up to, sorry, officer, as you're approaching, you can see in the video, you're approaching the defendant. There's a ditch there, but he's not in that ditch, correct?
There's snow right there, so there's.
So that's, you would, we just got that, so you would agree that that snow was there when you first made contact? Well, so first with the car, correct?
You refuse something, sir.
You first saw that snow would have been there when you first saw that car, the defendant's car as well, correct?
The snow?
Yes.
Yes,
So you would have been able to tell if he's in a ditch or not, correct?
I could.
But the video is clearly showing he's not in a ditch.
I believe in the video you can see tire tracks still lead to the actual driveway. I don't know if you could catch out of the right, it would be on the right side of the video.
But he's not in a ditch. We agree to that?
Yeah, hold it, guys. The witnesses on opinion would he observe this in person, was that this person or this defendant was in a ditch or partly in a ditch? So it would be argumentative trying to get.
Yeah, he has answered that 2 or 3 times.
What I would just say, credibility, you can take into account when you're making a ruling. That being said, it looks clear that the car is not in a ditch.
Okay, but you can argue that to the court, but you're asking him.
Fair enough.
And he said he's in a ditch 2 or 3 times, so you can certainly argue that. Go ahead.
Besides where the defendant is parked, is he committing, or has the defendant at this point committed any crime that you're aware of?
No, sir.
Has he committed any civil infraction that you're aware of?
No, sir.
So you have really no reason to come in contact, is that correct?
I don't believe so.
Well, what can you articulate would be some sort of reasonable suspicion or some sort of probable cause to investigate here?
Reasonable suspicion, I mean, car's running, there's tire tracks into a driveway.
Can you go, wait a minute, stop. Can you go back? I want to see that picture again that was being played. Show the road. Where was the roadway? Where was that at? Let me ask you this. Stop it in a second. Stop it. Right there. Stop it.
Yeah.
Now, correct me if I'm wrong. Is that a tree or a telephone pole straight ahead there?
I think it's a flagpole.
No, I'm not talking about, that's on the house. I'm looking at the right side of the roadway, officer. Can you tell what that is?
I believe that's a telephone pole.
All right. And he's off the roadway, right?
Right.
And that's Arsenal Road, left of the telephone pole, as you described it, going in which direction?
Northbound.
So he's on the east side of the road, off the road, correct?
That would be southbound, actually. I apologize.
Okay, so okay, there's nothing to apologize about. I just want to picture this. Straight ahead is southbound, correct? As this is depicted at, where's the time on that? 2:12, right?
Right.
So if that's southbound, he is on the west side of the road.
Right.
He's off the road.
Right.
There's a ditch that runs parallel, is what you're telling me, to the telephone pole.
Right.
So you come upon this vehicle that's off the roadway, correct?
Right.
That's basically in a yard there, right?
Right.
So I'm not sure why you were answering his questions in the manner that you were. I mean, don't you think that provided reasonable suspicion to believe that somebody had at least committed a civil infraction of improper lane use?
Yes.
Okay, go ahead.
Well, not rehabilitate at all.
Well, I didn't rehabilitate him.
You answered the question for me, and then you just re-asked the questions.
So I can do what I want. I'm the judge.
I agree.
Hang on a second. Listen. I'm trying to just picture what went on here. I don't know how somebody can answer a question and say there's no civil infraction occurring when somebody's driven off the roadway.
Well,
I mean, you can take it however you want. I would have done the same thing if she was asking questions. So go ahead. You finish your exam, but don't tell me I rehabilitated him. I have the right to ask questions. I have the right to understand what's going on here. He's off the road, right?
Right.
Okay, go ahead.
Being said, you don't know if he had permission to park in the person's yard, do you?
I do not.
Okay. You don't know if he was an invited guest there, correct?
Correct.
So there was, again, no reason to come in contact with the defendant. He wasn't breaking any laws and hadn't done anything at that point that was considered criminal in nature, or, as far as you were concerned, done anything wrong.
I believe that I explained there were tire tracks going into a driveway. I saw a vehicle running in front of somebody's house in a yard, so that is why.
But the car was not putting anyone in danger, correct?
The car wasn't, but the
There were,
intoxicated person that was.
there was, the car wasn't, there was nobody in immediate danger from that car, correct?
Correct.
There was nobody on the roadway, correct? That he could have potentially been hurt or put in danger, correct?
Not at that time.
Okay, so
There's vehicles traveling down that road at all hours of the day.
I need you to tell me where the tire tracks were.
The tracks,
Yeah, where did the tire tracks lead to?
the front yard. That is the-
Okay, I thought you said into the driveway.
No, so there's a part in the body cam where you can see there's tire tracks down a driveway, and then he is off to the left of those.
The tire tracks did not lead from the street to where his vehicle was. Is that fair or not fair?
Correct. So what I'm trying to have a vision is as I'm pulling around this way, there's a driveway here, down the driveway. Whoever lives at 26800 Arsenal, that's their driveway. I can see their tire tracks going all the way back to the end of their driveway. And then I see the blue Ford Explorer off to the left in the front yard of 26800.
that being said, again, you did not witness him put anyone in danger, correct? I have no further questions.
Can you redirect?
I just wanted to ask, so you stated, earlier it was stated that the defendant's vehicle was off the road. And there was some mention about this home and not knowing what it was supposed to be here. Is that a place you can park your vehicles off that road?
No.
Okay. Good.
The car was running, right?
Correct.
His foot was on the brake, you said. Is that right?
I didn't observe the foot. I just
I'm sorry.
observed the vehicle not.
I'm sorry, you observed.
I didn't observe the vehicle wasn't in park when I approached the window. I didn't observe his foot on the wrist.
The vehicle was running, right?
Correct.
So is it fair to say, maybe I misunderstood. Is it fair to say the vehicle was either in park, had to be in park then if his foot wasn't on the brake?
I just didn't look into the vehicle and look at his foot.
Okay.
I could just see the shifter wasn't in park.
The shifter was not in park?
When I observed him. When I knocked, when he came to, I instructed him to put the vehicle in the park.
Any other questions? Any other questions?
Just to clarify, so when you say you don't know whether his foot would be brake, is it because you didn't see his foot or because of something else?
It's because I didn't see his foot.
Okay, so you don't know whether it was in park or not,
I
or whether his foot was on the brake or not?
do not know whether his foot was on the brake.
Okay.
All right, you can step down, sir. Okay. You don't have anything. So what do you want to do? You moving to bind over or argue?
I think you're on that. You can take into account constitutional issues, and he clearly testified that he didn't have reason sufficient or probable cause to come in contact with the defendant. So there was no reason for that, for him to start an investigatory stop. No one was in danger. There was no criminal behavior afoot. He didn't observe anything. He couldn't articulate any particularized reason why he was coming into this defendant other than he believed he might be intoxicated. So there's been nothing that they presented that shows that he had a legitimate reason to come and contact you. So I'd actually deny the bind over.
And Your Honor, just in brief response to the one's not safe argument, he also did state that his reason for the stop was because the officer found it suspicious that the car was at the end of the driveway. He also stated that that's not an area you can park your car, and he made mention of these tire marks that we weren't able to see but were shown on the right side. He stated that the tire marks was straight, but his vehicle, the Blue Explorers, was off to the left side. So he approached the vehicle to investigate. I also point out the date of this incident being January 1st, 2026, which is 3 years as well, Your Honor. I believe that in itself is enough to at least conduct an investigation, see what's going on with this vehicle. So I believe that there is enough to find out.
Do you have anything else?
No, Your Honor, not this time.
To me, I don't care what he said. The car's in a ditch. It's off the road. It's running. Nobody's going to pull into a ditch. As far as I'm concerned, that qualifies as an accident. And it might just be by circumstantial evidence because he didn't see tire tracks. There was no evidence that he saw tire tracks leading off the road into the ditch. But people don't park in a ditch filled with snow unless there's an accident. And once there's an accident, the officer has the right to investigate. The car was running. It was running. I was unclear, but it sounds like the vehicle was not in park, which to me tells me, and it doesn't really matter, that his foot had to be on the brake as well. If the car's not in park and it's running, I don't know what other explanation that there would be other than the fact that his foot's on the brake. So to me, this qualifies as an accident, and the officer had reasonable suspicion to believe that the defendant was in an accident. Again, a car off a road running in a ditch that's not on a driveway or anything else. There's no evidence here. The court's not about to speculate to say that he could have been an invited guest or he could have been something else. It's not a place where people park cars. It's an accident. So I don't care how he qualifies it. At the worst, it's at the very least, it's improper lane use. You don't park on right-of-ways in houses. So I'm gonna bind over the defendant on the charge contained in the complaint and warrant. And if I'm wrong, I'll try never to be wrong again. But to me, this really, from all the cases that I read, I don't think that this is a question, but that they had the right to believe, he had reasonable suspicion to believe the defendant was in an accident. I'm going to bind the defendant over to the Wayne County Circuit Court. He's not in custody. I'm going to make it August the 18th. August the 18th at 9 o'clock in the morning on the charge contained in the complaint and warrant. I'm otherwise continuing the bond.
Thank you.
And we'll go from there, okay? So they'll give you your notice down the hall, sir. Good luck to you. Thank you. Thanks, everybody.
TCF Live on a Tuesday. We've got a full slate of programming here for you today at TCF at 2:30 Eastern, 11:30 Pacific. We will have second session. And then tonight, sidebar, 8 Eastern, 5 Pacific. So lots of stuff for you today. Let's go back to Texas. Let's check back in with Judge West.
Yes, no.
And Mr. Blewett's case in cause number 26 DCCR 0362 set for trial to begin with jury selection on August 17th. And what is the announcement?
Your Honor, I recently asked Mr. Coleman for some additional discovery involving a complaining witness. I sent him an email on, this was Thursday the 30th. I haven't heard back from him yet. I think it's pertinent to our case because of what it involves a complaining witness. So until I have an answer on that, I don't think I can make an announcement.
Mr. McElsley.
I show that some reports were added back in April, but nothing in the last week. So I'll have to check on that, Judge.
Okay.
I don't mind chasing him down. I know he's not in your court anymore. That's been
Yeah, we're working on some of those issues. So why don't I do this? I'm just going to I'm not gonna reset it at this point. If you can get with Mr.
got
Coleman,
confirmation.
we've
I
got
can
2
send that.
weeks for you guys to, if you'll kind of help out with that, get that information to Mr. Kelly, and then kind of let me know where we are. It's not the trial oldest one, but others are kind of falling apart, so you never know. Yeah, so I'll number it, but I'll also make a notation of that. Thank you,
Thank you.
Mr. Nichols.
Thank you.
You can go back with the bailiff.
Okie dokie, friends. I'll keep an eye for the next contestant here, but let's go to Louisiana, back to the board.
Hello? Yeah, can you hear me?
Yes, sir.
With the staff there, state their name for the record, please.
Deputy Long.
Thank you. My name is Chuck Tillis. I'm chairing today's committee. My colleagues are on Zoom, Ms. Jerry Ledoux and Mr. Steve Prater. Would you state your name and DOC number for the record, please?
Shannon Bertrand, number 623647.
Okay, do you have a questionnaire with you today?
Excuse me?
Do you have a questionnaire with you today that you signed?
No, sir, I don't have it on.
Okay, we're gonna print it out. Is that your signature?
Yes.
Do you wish to continue this hearing today?
Yes, sir.
Okay. Today, Mr. Prater will be handling your case, and I'm going to turn it over to Mr. Prater.
Okay, Mr. Bertrand, when you're released from jail on parole, you agree to abide by certain conditions. Today, we're here to discuss your violation or your suspected violations of condition 4 and condition 10. Let's go with number 10 first. It says that you owe $315 in back fees. Is that correct?
That's correct.
And so you plead guilty to that?
Yes, sir.
Okay. Well, let's move on to the more serious one. The first, there's 2 of them on number 4. One is that you you failed a drug screen, or admitted that you would fail a drug screen for PCP on September the 15th of 2025. Is that correct?
That's correct.
Okay, so you're pleading guilty to number 4. And the other number 4, the same condition but a different situation, took place where you were charged with indecent behavior with a juvenile. And that charge has subsequently been null-prossed. And we're aware of that, and we have all the reports. But were you charged with that?
Yes, sir, they charged me.
Were you guilty of that?
No, sir.
Okay. So we want to talk about, mainly we want to talk about that particular deal. I've read all the reports several times. It's a very convoluted deal, and I see we have someone that's going to speak to us on that matter in just a little while, and so we're going to let them speak to us. But would you tell me what the situation is before we talk to them?
Yes, sir. I woke up in the morning and I went to their apartment to talk to my brother, and then when I went in, my brother was asleep first, and I went in the kitchen to get something to drink, and then when I come out, the girl and my brother argued, so my brother leave out the apartment, and I picked the baby up because the baby was crying, and the girl was crying too, so she gave me a hug. She gave me a hug while we were the baby. Then the mother came in and she thought otherwise.
Okay, and the mother is going to be talking to us today. Is that correct?
Yes, sir, I see so.
And what is her name?
Maria.
Okay. All right, so you're saying you and the 16-year-old girl just hugged, correct?
Correct.
Okay. And we also have a couple of other people that are going to be speaking today, but I'd rather go ahead and get into this and get this cleared up to where we have an understanding of it before we talk to the other supporters of you not being revoked. So let's see, Miss Surfia, am I saying that right?
Yeah.
Miss Surfia, you're on. You're muted. There you go. Would you tell us about your relationship with this fella and tell us what you witnessed and what you're thinking?
Good morning. Well, we was in the past like maybe 2 years, we was talking only for a few days. It was like relationship, but only like few days. So.
Okay, so you and Shannon had a relationship?
Yes, we was in relationship.
Okay, and the 16-year-old the one he's accused of is related to you, is that correct?
Yeah, she's my daughter. Yeah.
Okay, that's your daughter, and you came in, saw them hugging, and called the police, correct?
Yes.
Okay, now the charges have since been dropped, and you had something to do with that, correct?
Yes.
Tell me about that.
How you say?
Tell me about that. Tell me what happened and what you feel like happened now and what your involvement now.
Well, the day I was working and Shannon go to visit his brother, right? So they was talking, and then my daughter and Mike was arguing, and Shannon was visit him. So he was hugging the baby, and when I come home, he was there, and my daughter was like giving a hug to him, but maybe they was talking like, something like telling, hey, don't worry because my argue with you or something. But I'm very restricted woman and very protective mother, So I was thinking divorce because yeah, but was a misunderstanding. I talked to my daughter and say, hey, what happened? She never lied to me. So I talked to her and she tell me, Mom, nothing happened. So he only was talking to me, about things of mine, don't argue with mine, and way me come home and everything.
So you don't think anything now? You don't think anything happened?
Well, I talked to my daughter. She never lied to me. I show her always tell me the truth, and I believe in my daughter. So she tell me, because I tell her, hey, you need to tell me the truth, and she said, Ma, I say, hey, look at my eyes, Melissa, and tell me the truth. So she talked to me. She said, Ma, nothing happened. Ma, I promise you nothing happened. And, was like talking a kind of way or something. Yeah. So, yeah.
Do you have a relationship with him now?
With who?
With Mr. Bertrand.
With Shannon?
Yeah.
No, we don't do that. Like, no, we don't got a relationship.
Okay. Why was he at your house?
How you say?
Why was he at your house with your daughter?
He was with my daughter in my house?
Yeah.
Well, he go visit the brother. And you don't know, I can control if the brother go there, to visit the brother.
And the brother goes with your daughter, correct?
How? Like you say, he stay in the house?
Do they date or anything?
You're talking about
About your daughter and
yeah, my daughter.
and Mr. Bertrand's brother.
Okay.
Do they see each other? Do they
Yes.
date?
Yes, they.
How old is Mr. Bertrand's brother?
He's almost 40. Today is 40.
He's 40 and your daughter is 16?
She talked to the brother. She misunderstanding what you're saying. She the one talk to my brother, Maria.
Oh, you say Shannon? Shannon, how he's 38, I think so.
Okay, he's 38 and your daughter is 16, correct?
Yes, correct.
Do they have a relationship? Is that what you're saying? Or you have a relationship with him, the brother?
Me?
Why is the brother at your house?
Well, look, me and Shannon was talking for a few days. When I come from New York, we was talking, and then we was talking then like, like maybe like friends or something, and then I meet Mike, is his brother, Mike. Mike. So he was living there too, because I was with him, with my baby daddy, It's Shannon's brother.
The baby daddy.
Yeah, it's Mike. It's
is
Mike.
Mike Bertrand?
Yes, sir. Yes.
Okay, and so Shannon was over there seeing Mike.
Yeah.
And the baby, and your 16-year-old daughter was there.
Yeah, exactly.
Okay, that's what I was trying to. The report is somewhat confusing about that issue, and I couldn't quite figure it out. Okay. All right. Well, we might come back to you, but let me go back to Mr. Bertrand. Mr. Bertrand, let's talk a minute about the failed drug screen when you admitted that you would fail it because of PCP. Have you ever gotten any treatment for the drugs?
No, sir. I was telling my parole officer I was going to go to the outpatient treatment, but the outpatient treatment wanted to charge me some money I ain't have. So I was my next plan was to go do some inpatient, then go to sober living.
Okay. How long have you been locked up?
Since November 1st.
Have you had any drugs since November?
No, sir.
Have you had a drug test since November?
No, sir. I've been incarcerated. No, sir.
How much longer do you have on your sentence? You got to be in jail until the 20th. If you do all of your time, you'll be locked up until 2028, correct?
Yes, sir.
Okay. All right. Well, let's hear from Shalisa Bertrand. Miss Shalisa, would you talk to us?
Yes, sir. Good morning. My name is Shalisa Bertrand. I am Shannon Bertrand's sister. Thank you for giving me the opportunity to speak today. I want to share what I have personally witnessed about Shannon and the person I know him to be. Like many people, Shannon has gone through difficult periods in his life. He's made mistakes, and I understand that he is responsible for the choices he made. I am not here to make excuses for him or to speak about anyone else. I simply want the board to know the man I have known my entire life. Shannon is a caring brother, a devoted father, and someone who has always loved his family. He is kind-hearted, and he has always been willing to help his family and the people that he loved. His actions during one period of his life do not define the person he truly is. One of Shannon's greatest source of pride is his son. This month, his son will begin college on a baseball scholarship, an achievement that reflects years of hard work and dedication. Shannon is incredibly proud of him and wants the opportunity to continue supporting and encouraging him as he begins his important new chapter in his life. Family has always been important to Shannon, and he wants to be a positive presence for his children and loved ones. Over the years, I have seen Shannon mature and reflect on the decisions that brought him here. I believe he has learned from his past and is committed to making a better choice in the future. He is given the opportunity to return home. Our family is fully prepared to support him, hold him accountable, and help him continue on a positive path. I respectfully ask the board to consider the whole person, not just the worst chapter of his life. And I believe Shannon has the ability to be productive and responsible member of the community, and our family will stand beside him every step of the way. Thank you for your time, your service, and your consideration for my statement.
Okay, thank you for those words. We appreciate that.
Yes,
Now, may we hear from Adeline Bertrand. Miss Adeline Bertrand.
Is she home?
My mom, she's working at the plant, and she probably had to step off, so she asked so I don't know. That's probably what it
So
is.
she may not be able to speak to us at this particular time.
Yeah, she hasn't got on.
Okay.
Okay, I'm on mute. Can y'all hear me? Okay, I had to turn the camera off because of the way I'm working at, but I'm here.
Okay.
Okay. Uh, okay, I'm gonna speak on behalf of my son Shannon Bertrand, as I call him McBride. He's my second born. He's the one that is more like me, the one his heart is, and I'm not just saying that. Shannon has a big heart, and sometimes I get upset with him because he have a tendency of putting others before him. That is where me and him fall out. But over the time, I saw Shannon make better decisions and everything, and he's learning to put himself first. Shannon will run out to go see about a friend, a brother, or sister before thinking about himself. And sometimes that had led him in situations that he shouldn't be in, caring too much. Shannon, when he put his mind to things, he's over accomplished. Shannon has the NCC PR in rigor, certification in rigor. Shannon also has a certification for small motor repairs. Shannon always been my honor roll student in school. Shannon is the one that if I'm sick or if anyone is sick in the house, he's the first one to notice. He's the one to clean up, and he gets nervous around dirtiness. But my thing is, I've seen growth in him. I know the core of this young man. Over the time of being locked up, I've seen it took a toll on him. The last time he was home, I see the slowness in him and everything. And I as a mother, I see the toll that it took. I look in his eyes. I could see he's tired. And I told Shannon, I said, Shannon, the thing that gets you in trouble when somebody call you, you go and see about them no matter what. And no matter what. And I see it all the time, but I know Shannon had made progress. He likes to work and go home and read. The only way he roll out that house if his brother or sister's calling him. He's going to see about him. but he's a good father. You know, nobody's perfect and everything, but when Shannon have a whole army of support, where I'm working at right now, I spoke with someone to kind of help him get his feet in the door. I'm at the plant with Shannon certification and everything. They have people that is willing to help him with that. I just hope that you can find it in your heart to let him come home. Um, I just hope that I know he's ready to to move forward in a positive direction. And I just want Shannon to put himself first and not to always go run with everybody calling him and he's getting a lot better. I've seen an improvement on that, you know. And his heart is too big. Too big. That's what me and him draw the line. My heart is not that big. But I'm hoping that you do take in consideration to let him come home and be with his family. He do have a stable place to live. My support, we will support him and encourage him, with all the conditions of his parole. We, as I'm speaking to me and his family, we're committed to helping him stay focused. And I do have a job lined up for him to build a better future, and so he can be involved in his children's life.
Okay, thank you. Thank you.
You're
We
welcome.
appreciate those words. All right, Mr. Bertrand, it sounds like we got two problems here. One we got is the money, which we're not going to, trust that you're going to get that paid back. So we're not going to take that off the table for now. The other is the drug problem is important to me because I think that's the crux to your problems. And just because you've been drug free, as you claim, for the last months, doesn't mean that you're out of the woods at all. So if I was to vote to not revoke you, but require you to find and fund, whether it be your family help you or whatever, a drug treatment program, and that you would attend AA meetings 3 days a week, and that you would stay away from this 16-year-old and her mother and their residents and stay completely away from them with something like a ordered protective order, but we're going to order it from the board. Would you be willing to do that?
Yes, sir. Yes, sir. I already had like the goal already to end the drug treatment and get all the help I need. Yes, sir. I'd be glad to cooperate.
Okay. Well, that's what I'm thinking, but I want to hear what my board members, what questions they might have, and see what suggestions they might have also, because the three of us work very well together, and we work to try to find out what's best for the folks that we're talking to. So, Mr. Chairman, that's all the questions I have.
Thank you, Mr. Prater. Ms. Ledoux, do you have any questions?
I do not. Thank you.
Mr. Prater, are you prepared to vote?
Yes, sir, I am. Okay, my vote is to not revoke you, but to require you to immediately, within 2 weeks, find you a drug treatment program, a drug substance abuse treatment program, and to attend it regularly and all sessions, and it to be funded within 30 days of you being released. And in the meantime, and afterwards, that you attend AA meetings or NA meetings 3 days a week for the next 6 months.
Okay.
And that you stay completely away from the reported complainant or victim in this case. You have nothing to do with her. Do not go over to that house or meet her anywhere or talk to her on the phone or have any contact with her or her mother at any time ever. Now, do you agree with those stipulations. I guess that would be in lieu of revocation. I'm not sure how we'll list it on the chart, but that's the requirements. Do you understand that?
Yes, sir. I'm sorry.
Okay. Board members, that's my vote. And if you think you need to fine tune any of the requirements for me, that'd be fine too. And we'll vote on it.
Thank you, Mr. Prater. Ms. Ledoux?
Concur.
And I also concur, Mr. Humphrey. Your parole has not been revoked today, and you'll have to follow those stipulations as Mr. Prater stated. This ends our business at the Calc issue.
Alrighty, friends. 10, 15 minutes, something like that left of TCF Live for today. Let's go back to Texas. New contestant in front of Judge West.
Are you Kevan Saunier?
Yes, ma'am.
And Mr. Saunier's case in clause number 25, DCCR 1530 is set for trial to begin with jury selection Monday, the 17th of August. And what is the announcement?
Judge, the state's ready. On the 16th of July, I filed a notice of intent to use business record affidavit. There's about 1,200 pages of medical records that have been added to discovery a few weeks ago. I'll, in candor to the court, we'll have to proceed most likely without the complaining witness. And that's how we're going to be presenting this case.
Okay.
So we can be ready.
Okay. Sounds good. And that was done a few weeks ago.
I believe the 16th was when it was filed.
Okay. Mr. Barbay?
Your Honor, if you would call the 260th court, I do have a trial set. In Judge Parkhurst, it's a murder trial.
Okay.
And I can be ready, whoever wants me.
Okay, sounds good. I'll look at our numbering on this one and take that into consideration. And if for some reason it looks like you're at the top, I'll see how old that one is and things like that. And we'll work it out and let you know.
Yes, sir.
All right, thank you. You can go back with the bailiff.
Lots of starts and stops today with Judge West. Sometimes it rolls that way. Let's go back to Judge McNally.
Good morning, Judge Staff. John Dustin, attorney on behalf of Melissa Park.
Ma'am, your name? All right, so you guys want me to adjourn this 2 more weeks?
That's correct.
I'm gonna adjourn it until August the 18th, and we'll make it at, what time, Lisa?
10:30.
10:30, you okay? You're all set, ma'am. You can go down the hall and get your notice, all right?
Thank you, Judge.
Thank you.
Judge, I'll talk with her.
Take your time. Just let me know.
Speaking of starts and stops, there we go again. How about Judge Mertz? Try that.
Okay, are you, ma'am, can you tell me your name, please?
Way. Amanda Way.
Thank you. We're on the record in People versus Amanda Way, file number 265223. The record should reflect that Ms. Way is appearing today by video from Wexford County Jail. And Mr. Seeger, can you address this file for us, please?
Your Honor, an offer has been extended wherein Ms. Way could plead to 1 count of possession of methamphetamine with no habitual offender notice, and all other counts would be dismissed.
Mr. Ziegler.
That's correct, Your Honor. Plead to count 1, dismiss the remainder.
Ms. Way, were you able to hear that?
Yes.
And is that the agreement that you've discussed with Mr. Seeger?
Yes.
Is that how you wanted to proceed today?
Yes.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Ms. Way, are you currently on any kind of probation or parole?
No.
You understand that by pleading guilty to, I'm sorry, was it count 1?
Correct.
Okay, by pleading guilty to count 1, that the maximum possible penalty you could face would be up to 10 years and or a $15,000 fine.
Yes.
With that in mind, what is your plea to that charge today?
Guilty.
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes.
Can you tell me what's going to happen to those rights by you pleading guilty?
I'm waiving them.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
Are you pleading guilty because you are actually guilty of this charge?
Yes.
The information I have indicates that this happened back on June 8th of this year, 2026. Is that correct?
Yes.
At that time, were you present here in Kalkaska County?
Yes, I was.
While you were here in Kalkaska County, did you have possession of some methamphetamine?
I did.
Did you know that that's what that substance was?
Yes.
Did you have any legal right to have any amount of it at that time?
No.
Thank you, Mr. Ziegler. Are the people satisfied with the factual basis?
I'm satisfied, Judge.
Mr. Seeger?
Yes, sir.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
No, sir.
Are you both satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Yes, sir.
Thank you. This way, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Between now and then, someone from probation will be in touch with you to prepare a pre-sentence report. Mr. Seeger, is there anything further on this file today?
Your Honor, the only addition would be that Ms. Way was hopeful that the court would consider allowing her to be released into treatment to the extent that she can become eligible. She's filled out some forms wherein I think that they were trying to wait to see what was going to happen with this file to determine whether or not she was going to be eligible. But clearly she does have a substance abuse problem that needs to be addressed, and she was hopeful that she would be able to address it in advance of sentencing as a matter of good faith, just generally showing that she is wanting to maintain her sobriety. Whether or not she's able to or not, I guess that's a different question. She has struggled at times, but I think that this period of incarceration has probably given her a little bit more clarity about what she needs to do going forward.
All right, so Ms. Way, I certainly would consider treatment as part of the sentence.
Okay.
But that's something that I would like to have the pre-sentence report so I can see kind of a little bit more about what happened in this case and your background.
Okay.
Before, I would make a final decision on that. So I'd like to have the sentencing hearing, but I would certainly consider treatment as, an option for sentencing.
Okay. Thank you.
Yeah. All right. Thank you. That's all for this hearing today. Anybody else at Wex?
Alrighty, friends, let's go back to Judge West, new contestant there, and we'll finish our day with her.
And this is cause number 26, DCCR 1178. Mr. Creation is charged with murder. And what is the announcement?
Your Honor, there are a couple of things, a couple of items that are missing, but it's the state's fault that I need to request. And there's also a guardhouse video that I'd like to schedule a time to be with Mr. Creation.
Okay.
And
I'm sorry
Yes,
to
ma'am.
interrupt. I certainly concur with Ms. Perazzo about that. I am still in the process of receiving discovery. Some scientific lab paperwork came in a week or so ago. We made sure to add that to the portal. It also involves the conflict we mentioned to the court yesterday that we've resolved with another individual who was before you that is a family member. So now that we have cleared up that issue, if you'll recall what I'm talking about, and I can fill you in on it.
Yeah.
It would allow me the opportunity now, as is my custom, sit down with the family. I wanted
Yes.
to do that before the court first, before I set that meeting, but I would like a
Okay.
chance to do that, make sure if Ms. Peraza, as she usually does, sends me a list of what she needs, we'll go through our files together.
Okay, well, sounds good. And so what we'll do is just get with Ms. Holmes and we'll have Mr. Creation brought over. You guys can watch
make
that
that
video down here in the jury room in the next couple of weeks and get everything hopefully together between now and that next court date. And we'll see where we are at the next court date.
Yes,
All right, you can go back with the bailiff, sir. And then you have
Alrighty, friends, that brings it to a close for TCF Live for this morning, but fear not, in about 2.5 hours, we will be back with second session. At the end of this stream, we'll redirect over there so you can set yourself a reminder. I hope you all had fun this morning. I know I did. I look forward to seeing you in a couple of hours, and we also have sidebar tonight, 8 p.m. Eastern, 5 p.m. Pacific. So thank you to everyone for just being with me today. I've really enjoyed it. Look forward to seeing you all real soon. In the meantime, go have yourselves a good day. Take care. God bless.